Looks like we've got Zoom. I'll get Kevin to sort my machine out. So we'll start with Gillian, and then we'll go back to Kate, if that was Kate on Zoom. Don't know that it is. So Gillian, 5 minutes, over to you.
Good afternoon. Thank you for the opportunity to talk. Tasman District Council has responsibilities for making our waters a safe and enjoyable place for all users, and this role extends out to 12 nautical miles. This is important because it means there should be room for everyone. The bylaw covers all water activities and sets out the local rules, complementing national rules to enhance water safety and ensure that people safely use and share our waterways. Consideration should also be given to the value of local waterways as wildlife habitats. The Waimea Inlet comprises river deltas and a convoluted coastline that are habitats for a great variety of species. The bylaw should consider this while deciding on navigation safety. The Council is expected to manage navigation safety for a variety of recreational water users. It follows on that in enclosed waters, there will need to be a hierarchy of users, with the needs of wildlife for safe nesting, resting areas being first consideration. Swimming and other such passive activities as kayaks and small racing sailing dinghies can safely and quietly use enclosed waterways. Motorised craft are noisy, fast and intrusive and should have no place in enclosed waters. These craft have all the space out to 12 nautical miles. There's no need to have them in any top of the south inlets or rivers. Sheltered inlets and rivers are prime habitats for birds and other wildlife. Swimming and quiet boating is sympathetic to the natural life found in enclosed waters. Motorised craft can use the whole area beyond where people swim and kayak. These craft belong in the open bay, not in the peaceful tidal waters of inlets. Such designated areas will give everyone more enjoyment than is currently possible, and also gives overdue consideration to bird life, which has had so much habitat taken away. Such a system will separate the different users and enable the Council to more easily manage maritime safety risks in Tasman waters. Thank you.
Thank you, Gillian. Well done. Thanks for the submission. I don't think we've got any spare time because we're running a bit late. If anybody had any questions, but I don't think they will. That's clear. We'll try now to see if we can get Kate Mitchell. Is that Kate on Zoom?
I am on Zoom. Can you hear me all right?
We can, Kate. We've had some technology problems, so you've got 5 minutes and we can see you as well. So.
Okay, great. I made it through your first intelligence test, so that's a bonus. Kia ora koutou. I'm Kate Mitchell. I am Judy's daughter. I think she spoke earlier. I also grew up in Mapua, and my children and my husband and I spend a lot of time in Mapua still, and I'm a trustee of a trust that owns property on Aranui Road. Thanks for the opportunity to speak. I'll try and be quick. I've got a couple of points that relate to actual wording, so through the chair, if you want to stop me to clarify anything, please feel free. But I really just want to make 3 main points. And my submission's quite focused on the Mapua Wharf and wanting to preserve the ability for swimmers, jumpers and public to use the wharf and channel, and as we currently do, and that the bylaw doesn't change this. And so in that respect, I oppose the wording of clause 12.1 as it is in the draft that was notified, and note and endorse the strong opposition and feedback to the wording of that clause as it related to landing places and the unintentional banning of swimming or diving around landing places, and in particular in our case the Mapua Wharf. I'd like to strongly support the submitters' feedback and my own feedback that emphasise both visitors and Mapua communities' enjoyment of the wharf jumping, bringing family and tourists to the wharf area, the shops and bars, and that I'd really like to emphasise this. Common sense has always been exercised by all in respect of the wharf area ever since I was a child, in terms of the sort of competing community uses of the wharf. My submission remains that the Mapua Wharf should be an exception to Rule 12.5 because of its unique and special nature as a community facility. I query the appropriateness of that rule, which gives priority to boat users applying to the Mapua Wharf, because it's completely different to the other landing places covered by the rule and the other identified places, which include large ship anchorages and commercial port areas at Tarakohi and at Motueka. However, as an alternative, if you as a council determine that the rule should apply, I'd like to strongly support the amended staff recommended wording for clause 12.1, which is immensely preferable. In respect of the staff recommendation, I'd just like to thank the council officer for taking on board the community concerns and attempting to address them in the wording of the rule. Generally, think that, subject to my kind of first preference, think that the wording is good, but I would like to seek that for clarity, the explanatory note, which is noted in the rule, be included in the rule itself. And I can email through my suggestion if that would be helpful, but what I'm suggesting is this could be done by adding to subclause A, a new Roman numeral 3, which states that, and the activity restriction applies only to that part of a landing place, i.e. a berth, where actual vessel movement is taking place, not to the entire landing place structure. So that's the change I'm seeking. I can email that through. Just in the officer's report, I noted there was another amended change to the wording at 12.1c, which added the wording marked navigational channel or any other navigational channel leading to a landing place. I couldn't find any interpretation for navigational channel or definition in the bylaw, but navigable is defined as being able to be navigated by a vessel on, through, over or underwater. So I thought that seemed really broad. It could mean the whole channel, and I'm just seeking that the council consider if that wording is going to be adopted, that a definition be included so that we avoid the whole channel being caught by that rule. My final point just relates to the speed of vessels. This is just something I picked up through my sister, to be honest, but clause 29.1 in relation to the speed of vessels says a person may not, without reasonable excuse, operate a vessel at a proper speed exceeding 5 knots within 50 metres of any other vessel, raft or person, or 200 metres of shore. And then at schedule 1.14, which has got the Mapua channel, is different wording again. It says the speed limit within 50 metres of any other vessel or person in the water remains as 5 knots, or where 5 knots is not practicable, the slowest practicable speed. Both those seem to be additional tests or an additional gloss on the maritime safety rule, which to me seems to actually conflict with the rule. The rule is clear that you must not exceed a speed of 5 knots if you are within 200 metres of the shore, 200 metres of any structure, 50 metres of any boat, or 50 metres of a person swimming. And I think the wording that's been put there, for a start, I think it would need to be consistent, but it also is quite ambiguous and adds an element of judgment as to when something is not practicable or when it's not with a reasonable excuse. And there's no definition for what that means. And it seems to me that that would conflict with the wording of the maritime safety rule and would be really difficult to enforce. So submit that those glosses should be removed. Thank you.
Thanks, Kate. You're only just a bit over time.
Oh,
That's
sorry.
fine.
Tried to be fast.
Yeah, that's okay. Thank you very much for your submission, and thanks for your patience, because we certainly had some trouble with Zoom today.
No problem. Thank you.
Okay. Next up is John Lyon. Is that how you pronounce it, John?
John Leydon, actually.
John Leydon?
Yeah.
Okay. And you've got some props, so that's good. So, tell me when I'm starting. Okay. I can't sit down and do this, I'm sorry. If you can't hear me, I'll stand over there.
No, just nobody on Zoom can hear you.
Oh. Right. Testing. My concern is that in my submission, there are no definitions in the TDC proposed navigation bylaw for a life jacket. You want us to wear life jackets, it's compulsory under 6 metres, you don't say what a life jacket is. I'm not going to tell you a life jacket, so I'm going to show you. That's back in the day, 1960s, standard life jacket. Lots of buoyancy in the front, cushion at the back. Designed to float you on your back when you're unconscious. That's a life jacket. The modern version is solid foam. Still has a cushion. Still has most of the buoyancy in the front. It's not guaranteed because it's not a full size one, but it's not guaranteed to float you on your back if you're unconscious, but it's designed to do that. It certainly gives you a lot of help. For water sports, this is a general device called a buoyancy aid. It's not designed to float you on your back, it's designed to float you. It's easy to swim in, it's easy to paddle, it's easy to sail, it's easy to fish, it's easy to do anything. It's warm, it gives you some insulation, it gives you some body padding. That's a buoyancy aid. Life jackets, collars, buoyancy in the front, and a clutch strap goes through legs for children. So the two small sizes of life jackets have to have a clutch strap in order to qualify. This is a life buoy. If in section 8 you're talking about chucking buoyancy aids to people, presume you're going to chuck that and not that. Because that is a PFD under the meaning of the rule. But I keep reading, I'll tell you when to stop.
What do you want me?
Doesn't it?
I
It says on here, but it's not a PFD. So you know what that means? If everybody wears these things, when they cross the bar and hasn't just capital, they're not compliant. You need a rule that does something about that. How can the harbour master enforce a rule that's not a rule? So here I am. I'm out fishing or whatever. I get chucked overboard. I'm secure as a bug in a rug. Providing when I've fallen in the water, got over the shock, I'm trying to stay afloat, providing somewhere I can pull this. After a broken jaw, I've survived. Well, that seems like a good idea, you guys. Then fair enough. That wasn't pleasant. Now, it's a life jacket, fully qualified Australian standards. Now, the New Zealand standards don't, in the Marine Navigation Act, don't say they incorporated Australian standards. You might have seen people wearing these. They usually wear them on the back, but you can't let them go on the back. This is a high cost, low profile one. This one here is a cheapie. Like the one in the front, somewhere. I've fallen off the paddle board. I've got a tether on my ankle. I'm getting towed at 3-knot current, upside down, backwards. I'm trying to stay afloat. And down here, a metre under the water, I'm trying to find a trigger to save myself. How do you feel? You're making the law for your 11-year-old granddaughter, for your wives, for your kids. Finally, I've tried it. So now I'm sinking, but I've got a thing on my stomach. All I've got to do is take both hands off, put this over my head, and save myself. I'm still getting towed by my 1 foot on a paddleboard.
Thanks, guys.
Thanks, John. I hadn't even seen half of some of those,
That's why I'm here.
and I've
Is the
only
harbour
got,
master on this team?
no. The harbour master's a staff member, he's behind you.
So what qualifications have you guys got?
We're councillors as the hearings committee. I've been a boat owner, been involved in boats for over 50 years. Okay? But
Well, if you need help with the dam, give us a ring.
the dam's finished. And this hearing's not about that. Right. We've got Kate McNabb next. And I understand Kate's here. If you'd like to come and take a seat, once John's got all his props. And thanks, John.
I'll take my balloons away.
Yeah. Grab a seat and you might want to pull the microphone down. Thanks.
Yeah, I am quite short. Right. Tēnā kia ora koutou, Catherine McNabb, otherwise known as Katie. Toko ingoa. Thank you very much for allowing me to come speak today. I'm speaking on behalf of Jet Boating New Zealand. We're a national organisation, and we filed an initial submission, which you all have copies of, and then a supplementary submission, which you also have copies of. Thank you very much for removing the advisory clause from the uplifting section on for allowing us to boat rivers, because consistency is pivotal to good compliance. And that's a really important point for Jet Boating New Zealand. We work really hard to get our members to comply, but where we have inconsistencies, it's incredibly difficult. It's like having pink stop signs in Auckland and blue ones in Canterbury. So you're the only area that have that advisory clause, which brings me to the other part of the submission that's really important to us, which was the addition of the flow regimes into the bylaws in 2015. They serve no purpose for safety at all. They're impossible to communicate. We communicate them to our members, but you know, a river can be 60 cumecs 1 minute, it can be 70 or 80 an hour or so later, or it can drop. So having a cumec rating is like saying, well, I'm sorry, you can't go boating from Kaiteria unless it's mid-tide or above. There are no other cumec ratings of this nature in New Zealand. They would be there if they were on the district plan, or perhaps fishing or something like that, but there's nothing, nowhere else in New Zealand do we have cumec ratings on rivers for boating. So we would ask, and very clearly ask, that that is removed. Please, pretty please. So one of the more concerning things that came through when I read the rest of the submissions was that the significant number of kayak operators from the Upper Buller River who don't seem to be aware that jet boating has been taking place there lawfully for 70 years, that the rules were specifically uplifted in 1991, and that they also have an obligation to follow maritime rules. Because they work under HASWA legislation within New Zealand venture regulations, they're probably not as aware as they could be. That the regulations also mean that they must stay to the starboard side of the river as best they can at all times. We saw similar submissions from them in 2004 when we got the upper part of the Buller uplifted from the Mangles and above. And it seemed then they didn't understand the rules, and 20 years later they don't either. So we'd ask that the Tasman Council do some work with those operators and teachers to make sure that they're aware, and that their students are as well. So does anyone have any questions in particular?
Got some time? If somebody... Councillor Dakey?
Yes, councillor.
Yes, thank you. So Waimea River's got a cubic rating on it.
Mm.
I think it's 20 cubics is the recommended. Your members, what sort of flows would they be going out in?
Well, if it's a rising river, they wouldn't be.
Yeah.
If it's a dropping river, they won't boat unless it's safe and they can get up there. So it's like asking what breeze you'd sail in. I mean, it could be 5 knots or 15, but is it gusty? Is it from the southeast? Is it from the north? It's a judgment call, and the legislation in Rule 22 is skipper responsibility. So it's the same with all rivers. I mean, you know, rivers in Canterbury can go up to 1,000 cumecs in a few hours and be at 30, say, in the middle of the day, and by the middle of the day, the next day, there'll be 1,000 cumecs. So it's just unworkable. And I suggest that the 80% of people who don't belong to Debt Boating New Zealand have no idea that that rule's there and just happily carry on boating.
Okay, thank you.
I ask something?
No, you can't. You get to speak when you're submitted for 5 minutes, and you can't ask anything from the gallery. Sorry. Okay. Well, that's fine, Kate.
All right?
Yep, that's the
All
time.
good.
We've read your submission.
Thank you. I came up from Southern Lakes to do this today because we regard it as very important to have consistency throughout the country.
Right.
Thank you very much, gentlemen, for your time. And
Thank you. Yeah, I've got family that have been jet boat owners, so I'm well aware of what they do.
Good. I hope you've had the opportunity to enjoy some jet boating.
I have on many occasions. I think I've got David Sissons. Is that next?
We're going to dial back to Sonja.
Oh, Sonja Mitchell's here. Oh, Sonja Mitchell. I think you're on Zoom, so you've come in a bit later. So we're going to just go back to you, Sonja, and then we'll go forward. So Sonja, you've got 5 minutes. If you want some questions, you have to finish before the 5 minutes to get them.
Sure, thank you. Yeah, I've been sort of available since 12:30, just struggling to get in.
Yeah, we couldn't get it to work.
No, all good. Kei te mihi te uri nei o Ngāti tō rangatira o Ngāti Pakeha hoki kia koutou katoa. Tēnā koutou nā mangai, nā councillors, Mailing, Butler, Dakey and Dowler. Kia koutou katoa, ko hui mai tēnei te mihi nui kia koutou. Ko Sonja Mitchell toko ingoa, my name is Sonja. And I firstly wanted to just express some concern about the process by which this draft bylaw has been prepared. It seems to have been confusing and rushed. We've had, during the consultation period, 3 different drafts of the bylaw. We've had 3 different versions of wording relating to that swimming provision. And that's made it really quite difficult to engage with. It's also unclear what the relationship of this draft bylaw is with the 2015 bylaw. The 2015 bylaw seems to be replaced by this one, but there's nothing that tells us what's been dropped from the previous bylaw, what's been carried over and why, and what's brand new text. So overall, I think the draft bylaw is quite confusing. I think the wording in it is quite technocratic. It doesn't seem to be written for the general public. So there's just some general comments. The stated rationale of the bylaw isn't achieved. That bylaw is that the council has responsibilities for making our waters a safe and enjoyable place for everyone. And I emphasize those words, enjoyable and for everyone. Because this draft bylaw privileges boat users over others' use and enjoyment of the marine environment, and even over the state and health of the marine environment itself, including the bird, fish, plant life it supports. I heard just a snippet of Gillian's submission, and I support that submission and any submission by Forest and Bird on this issue. The scope of the bylaw is simply too narrow. It's focused on maritime health and safety. But people's enjoyment of the marine environment goes far beyond maritime health and safety. It relates to the state of that natural environment and our ability to enjoy it in ways that don't include boating. The draft bylaw inappropriately and unreasonably restricts swimming, diving, etc. near any landing place, paragraph 12. And that's in contrast to the 2015 navigational bylaw, which only prevented swimming, diving and jumping at the 2 commercial wharves, Motueka and Tarakohe. So that's a really unjustified restriction that came into that draft wording. I understand there's some amended wording from staff. I've only received that 2 days ago, so I'm not really going to comment on that here other than to say it looks like it's marginally better, but it still seems to put the onus on swimmers to get out of the way of boats, whereas boats really should be getting out of the way of swimmers because they are the more dangerous use of the marine environment. The restrictions on swimming, diving, etc. appear to be inconsistent with the New Zealand Bill of Rights and the UN Universal Declaration of Human Rights, which includes the right of freedom of movement. So people's freedom of movement in the marine environment should only be restricted if there's really sound rationale. I can't see that rationale in this document. The bylaw contains inadequate restrictions on the speed boats can go near swimmers. So my sister spoke to this as well, and I'll just add briefly. The Maritime New Zealand rules really clearly state that vessels must not exceed 5 knots within 50 metres of a person swimming or within 200 metres of any structure. But the wording in this draft bylaw is far more loose. So paragraph 29.1 allows boaties a reasonable excuse for exceeding 5 knots. The table, the map, sorry, in schedule 1.14, page 54, provides for 5 knots or the slowest practicable speed. So again, there's a real watering down, and that seems to be a change from the original 2015 bylaw as well. And I don't know why that change would be allowed when it clearly renders everyone else in the marine environment less safe. I was confused by the speed uplift provisions and the exceptions that can be made to the 5 knots rule. And again, I just say that those New Zealand maritime rules should be maintained and not in any way watered down. In terms of moorings, there seems to be a lack of provision for considering the environment, including the impacts of moorings, such as increased pollution caused by power boats, increased noise, which affects bird life and fish life, including in the Waimea estuary, damage to the seafloor, and it also affects others' ability to enjoy the marine environment because of an increase of boats and power boats. So to conclude, the draft bylaw seems to have been produced by a rushed and confusing, flawed process. It doesn't seem to achieve the stated rationale. It privileges boat users over all other users and over the marine environment and the health of the marine environment itself. It places too many restrictions on swimmers, divers, etc., and too few on boat speeds. And finally, it seems to be a document written by boaties and for boaties, and not with the interests of the wider public in mind, nor the interests of the natural environment. Kia ora koutou. Happy to take questions if there are any.
No, you're well over time now, so we won't have any questions, Sonja.
Okay.
Okay. All right. So thank you very much for your submission. It's well spoken to. Okay.
Thanks for your time.
So,
Kia ora.
right, thank you. Right, now if I go on to the ones on the green. So if I had John, Jessica Matheson, not here? She's on Zoom. Jessica, you're on Zoom. Oh yeah, I hadn't seen the Zoom, but you're from the Kayak school, so you get 5 minutes. If you use all your 5 minutes speaking, you won't get any questions, okay?
I actually have got my 3-year-old at home down the hall, so hopefully she stays out the way. But anyway, hey, thank you for the opportunity to speak. My name's Jess Matheson, and I'm the co-owner of the New Zealand Kayak School in Murchison. My submission was quite short, but relates to Schedule 2.7, which is the Buller River and the tributaries. And the submission supports I've just got notes everywhere, supports the continued implementation of where essentially the Buller section of the Buller upstream of the Murchison Township is protected during the summer it has a 5-knot speed limit is what I'm trying to get to, and we support holding that speed limit. The section of river upstream of Murchison, we'd been contacted by the Jet Boat Association asking us to just give our permission for that for there to be a speed uplift all year round, and we can't do that. We counted that we reckon there's over 50 different users of polytechs, schools, businesses, organisations and private users and clubs that are on the section of river, and it's probably one of the best moderate, easy to moderate sections of river available in the country, and people come from all over New Zealand to use that particular section. And so for us, the way that the bylaw is written will protect that section, and primarily the river users, in terms of not being required to look out for jet boats during the peak summer, when often those sections can be incredibly busy. When we say the easy section of water, generally most of that heading upstream in Murchison is around the class 2 difficulty, which means that you've often got beginner and intermediate kayakers, and often if they're having a hard time, they'll be out of their boat. And so for us, what that looks like is the jet boats being with the speed limit as it is, it just means that the safety of beginner river users is protected. There's also people that are gold mining, gold panning, people that are doing river floats with their families and young children. So we're on board for the continuation of the bylaw as it is. We've been Jet Boat New Zealand would like us to say something different, but I'm sorry, we support that, and that our view represents pretty much all the other river users for that section. I understand there's other areas for jet boats, and it may be an inconvenience to have that one section with a speed limit, but we support that. Super happy to. I also just quick note that apparently the maritime rules would mean that we need to be on starboard at all times, which is just completely impractical when you're navigating a river back and forth. So yeah, I think that was Kate from Jet Boating New Zealand. I was just listening to that, but that's where we're coming from. Stick with it, please. I'm happy to answer any questions.
None of us have got questions. We got a number of submissions from the kayak people, so we know where you're coming from.
Yeah, I do recognize convenience for others, in particular jet boats, but just that one long section is just so used that even when we have encountered jet boats up there who often are unaware of the bylaw, that we do our best to kind of educate, but even then, it's pretty terrifying for people on the river and often quite surprising for jet boats. So please maintain that. We support that.
Okay, that's fine. Thanks very much for your submission, and you're very clear. Okay. So thanks, Jessica. And
all the best for your.
Yeah, I'm glad Zoom's working better now, so I've certainly made it able. I've got David Sissons next. So David, if you'd like to come up, and if we could turn that mic on and off.
This one, it's on.
Yeah, it's on at the moment, so that's good. So David, I think I've seen you here before over the years.
Thank you. Yes.
Yeah. So
I'll be very brief this time. You've got lots of very important things to talk about, to listen to. I'm David Sissons for the Waimea Inlet Forum. Thank you for this chance to speak to you. We support the registration of motorised craft, especially jet skis. And we do appreciate that our main concern is not a safety issue, but we do want to take this brief opportunity to tell you our concern about the way powered craft and jet skis in particular do disturb the birds in Waimea Inlet, especially around No Man's Island and the mouth of the Waimea River. We've been expressing our concern about this since the Waimea Inlet strategy was first adopted by the Council in 2010. And then in 2011, the coastal marine part of the Tasman Resource Management Plan became operative. Chapter 20 addresses this very matter, and the methods of implementation include a bylaw to protect against disturbance of wildlife. And here we are, 13 years later, and still there is no bylaw, and the wildlife continues to be disturbed. That's all. Thank you very much for the opportunity to say that. I can answer any questions if you want me to.
Thank you, David. I'll just see if there's any questions. It's pretty clear what you want. No, there's no questions. Okay, thanks, David. Good to see you again. And thank you for all the work that you do at the inlet. I've got Kim Bowie. Kim?
Yeah.
Right. Yeah, so I think the staff are going to put it up. So. Right. Oh, it's still going now. Ah, there it is. I'm Kim Bowie and I'm presenting on behalf of my partner Elspeth Collier. And it's timely that I'm following on from David because it's specifically in relation to the Waimea Inlet. And our contention is that the draft navigation bylaw 2024 fails to consider the impact of motorcraft on the flora and fauna of the inlet and the marine environment. Is it possible to, can I move those pictures or?
Who's going to try and drive the machine?
Oh, there we are. That's all right.
Technology's never easy. Well, not for me. Anyway.
Am I going to drive it? Okay. So, yes. Okay. We live at the northwestern end of the inlet. Okay. And our home overlooks the northwestern end of the inlet. So we're regularly in touch with the flora and fauna, watching the birds feeding, resting, roosting, etc. That's just a photograph from home. I don't quite know. Ah, there we are. That's a pretty typical flock of spoonbills that are resting on a little high tide roost in the middle of the inlet. Shorebirds regularly feeding on the edges of the inlet and channels, and you'll see there probably a mixture of stilts, plovers, possibly godwits. In fact, there are godwits there in that picture. Oyster catchers. Another picture of them feeding on the channel. Now, my point is, our point is, that the boats and we've noticed every year the number of jet skis is increasing. The jet skis obviously can navigate the channels more easily than the larger boats, and they're regularly exceeding 5 knots within 200 metres of the shore. We have no way of policing the speed limits, and we support the proposed identification of motorised craft. I mean, you can see the wakes that they create. They're clearly going over 5 knots, and the wakes they create are disturbing wildlife on regular occasions. That picture there is a classic. That's just off Higgs Reserve, and you can see how close they are to the shore. David mentioned No Man's Island. Actually, before I mention No Man's Island, jet skis, they continue to increase in popularity, and my understanding is they're going down in price. They're becoming more affordable. And we noticed recently in an April issue of Kia Ora magazine featured a story about water recreation in our region, and it was titled Nelson Tasman from the Sea. In the article under a heading Fast Times, there is an invitation to hire the jet skis on the Waimea Inlet. And I'll quote from the article, the sheltered estuarine water on the land side of Motoroa Rabbit Island is ideal for a Zen state kayak or for ripping it up on a jet ski equivalent of a motocross bike. So the noise and wake of the skis, particularly if they're performing water wheelies, as promoted in the article, causes extreme disturbance to the many birds that roost at high tide on the shore in the sand islands of the inlet. And I think David might have mentioned the chapter 20 of the resource management plan, where there's I'll quote it, to avoid, remedy or mitigate adverse effects on amenity values and natural values, including a disturbance of wildlife or marine mammals. We would like to see that enacted more.
vigorously. There's a new threat to wildlife disturbance, and that's e-foils. They can travel at speeds in excess of 60 kilometres an hour. Last summer, the Waikato Regional Harbour Master noted the increasing use of these, and I quote from an article he was talking in. They've got these big foils underneath that if they were to connect with somebody, it's a significant injury coming or worse. Many people buy them without any real understanding of the rules on the water. He adds that he wants to get on top of things before they get out of control. So we support the proposed introduction in the new bylaw of compulsory identification of vessels. This would solve the problem of not being able to identify watercraft that are breaking navigation rules. Penalties and how they would be administered also needs clarification. And referring to No Man's Island, oh, that's a classic picture there. Look at that jet ski just navigating its way up the Pearl Creek Delta. I mean, it's just extraordinary that that was able to happen without any sort of identification. No Man's Island and the surrounding intertidal flats are located opposite Grossie Point. No Man's Island is internationally significant and protected as a nature reserve. Human access is prohibited on the island because it's a nesting place for variable oyster catchers, black-backed gulls, Caspian terns, etc. It supports a diverse community of salt flat vegetation. The intertidal flats are a vital source of food for fish and birds, and the island is a high tide roost for wading birds. Despite the ban on human access, there's someone there. The island is increasingly being used by people for fishing and is becoming a popular landing spot for jet skiers. The protection of wildlife from the effects of boats, jet skis and e-foils must be included in the navigation bylaw.
We're over 5 minutes, so if you just...
I'm just finishing. With increasing popularity of jet skis, the arrival of e-foils, the probable doubling of the population of Mapua and the surrounding district over the next few years, and the possibility of a new boat ramp in Mapua, now is the time to update the local marine navigation rules so that they will protect the precious flora and fauna of the Waimea Inlet in perpetuity. And that's the main thrust of this submission. Thank you.
Thanks, Kim. That's well done. And I certainly enjoyed the presentation. No question, we're over time.
Am I able to I had a question before with Kate. Am I able to ask that question?
You can ask, but we might not answer it as a panel.
I was just, well, it was really a comment that she was talking about the QMAC flows on the rivers. Is that a function of TDC or responsibility of TDC, or is it a function of NIWA who have a responsibility or have their task is to monitor those flows?
We monitor, look, I can tell you the council's monitoring, and it's on our website. So I know what the flows are all the time because I watch it for flooding, and also I'm a trout fisherman as well. So
yeah, so
it's a regional responsibility that we monitor those flows, and it's available on our website. And there are hundreds of, well, maybe not hundreds, but pretty close to 100 monitoring sites on rivers
administered by TDC.
Yep, it's on our website. We're the regulatory authority. So we're the regulatory authority, and we provide that information.
Right.
All right. And there's warnings go out when there's heavy floods. But anyway, we need to keep going. So it's our job. So I've got next here, I think is it Chris Roff or Roth? Chris Roff? Chris, welcome. And if you just like to come up and use, you just switch that microphone on. So.
Hey, kia ora everyone. Thanks for this opportunity. There's two parts of the bylaw that I wanted to talk about. Just to give it some context, I'm a commercial operator, but also a sailor for pleasure. I'm the principal and chief instructor of Sail Nelson. So it's a sailing school that operates out of Nelson and is regulated by Nelson. I'm very heavily regulated by Maritime New Zealand, Nelson City Council, Department of Conservation, and the Royal Yachting Association, whose scheme I follow to teach navigation and safety at sea. So I run 5-day cruising courses on two sailing vessels, which do sail through Tasman District Council waters reasonably regularly in the summer. My first thing I'm objecting to is that the council, Tasman District Council, are proposing to impose additional rules and regulations as to how my boats should be equipped. Specifically, because I teach navigation at night, so operate at night, there's a proposal that I'll have to carry AIS on my vessels. As far as I'm concerned, Maritime New Zealand regulates how my boats are equipped, and I'm under a MOS safety plan, and I don't think it's appropriate for Tasman District Council to be setting themselves up as a maritime regulator in that respect. If, for example, Nelson City Council were to operate a similar system, as I say, I teach up to, well, I do teach up to yachtmaster level. I might go and visit Wellington. I might go and visit New Plymouth for longer trips. If all those councils are all to implement similar fees or requirements, then it puts my the sort of viability of my business in jeopardy. So yeah, I'm just wanted to reiterate that I don't feel it's appropriate for Tasman District Council to be prescribing what equipment I should be carrying over and above what Maritime New Zealand require from me. The second one was about charging fees or a charge, whatever form you want to call it, that's going to cover the cost of the temporary voyage that goes into mostly around the Able Tasman. As a commercial operator, as a commercial sailor, I have no need for any of that voyage. And it's not particularly useful to me. There's a few little so-called cardinal marks, which have the correct top mark, but don't comply with international voyage. They don't have the right colorings on them. They're put on certain specific hazards, but not all of them, so they're not consistent. There are plenty of other hazards that are not marked. And then there's the buoys around all the around at Adele Island and at Anchorage. Now, presumably, marking those anchorage areas is to try and stop people going too fast through Anchorage as well. Big vessels and water taxis regularly go up and down through the Astrolabe roadstead, and as anyone who considers a tsunami knows, the wake those boats create travels all the way across and through the anchorage, regardless of whether those yellow buoys are there or not. And for vessels operating, there's already a rule to travel slowly next to anchored vessels, 50 meters from another vessel. So those buoys don't really serve any purpose. And the same at Anchorage, next to Torrent Bay. Those yellow buoys are right opposite a water ski lane. So again, they're a bit pointless because the wake travels across through those anchorages regardless. So, if those buoys are considered necessary by TDC, then they're there for the benefit of the recreational boaties with less maritime knowledge than the commercial operators. I don't see how any commercial operator requires those buoys to be there, and I don't think it's appropriate that the commercial operators should be paying for their installation. So that's really all I have to say. So thank you for your time.
Okay, I'll just check. Have you got a question? Councillor Dakey's got a question.
Thank you, Chris. Just regards to the AIS, your operation is mainly being captured because of nighttime, or is there other rules that would?
That's the only thing I can see in there that would require me to have AIS because I operate at night. But it's also the general principle of a local council starting to stipulate what equipment a commercial operator under a MOS system is required to carry. I have a really good relationship with the Nelson Harbour Master and work very closely with him. I'd like to have the same with the Tasman Harbour Master and work collaboratively and not feel that I'm having to kind of watch my back and fight against him. We can work together.
Yeah, thank you, Chris. Understood.
All right, well, thanks very much.
Thanks.
Right, just have a look. We got so it was Martin, wasn't it? Yeah, Martin Holmes. Afternoon, Martin. So you've seen the drill?
and you've got 5 minutes. Up to you how you use that time.
Okay, guys, thanks for speaking, or for me to have a chance to speak. I'm Martin Holmes. I think I have a fairly extensive maritime history behind me. Maritime fitter and turner, chief engineer for 10 years on fishing vessels and vessels, super yacht skipper and charter boat operator and overseas for 6 years, and now 25 years operating charter boats here in Nelson. So 40 years sailing here locally. I know the place. I've seen lots of people come and go. First thing I'd like to say is rules don't fix things. Don't make rules that cannot be policed or cannot be managed. For instance, little things like naming a foil board. The only way you can see the name on a foil board, which is that big, is to go up and read the name on the board. It's impossible. It's not going to make any difference. An example of a rule that's not worth having. Okay. First thing I want to speak about, apart from that, is 7.3, requirement to wear flotation devices on small vessels. Okay, our operation, we operate several types of vessels, beach landing catamarans, but also relatively shallow draft catamarans operating, for instance, out of Kaiteri. The vessel draws 1 metre, so therefore we cannot pull up directly on the beach to load people. The loading for us, it means using a small inflatable dinghy and transferring people from the shore to the boat. We could have up to 20 people to transfer. The dinghy's certified for 5 people. That's 4 trips. We've got a mother vessel sitting offshore. It may be only in 1.5 metres of water. The people could walk to the boat. They wouldn't need to wear a life jacket. They can swim to the boat. They wouldn't need a life jacket. They can paddle on a lilo and they don't need a life jacket. But to put them in my inflatable certified boat and take them to the boat to get on board, they supposedly are going to need a life jacket. Seems a bit silly, eh? Okay, so we can get around that. Is there was 7.3 for exemptions. If there's something could be included in the exemptions, another word, for instance, so that we would not need to wear those life jackets to get to the vessels, that would be great. I fully agree that small vessels that are travelling independently by themselves at sea, people should have life jackets on board them, but big picture stuff. There's lots of small users, so we've got to work around them. Okay, second thing I want to talk about is AIS. Okay, AIS, there's lots of different versions of AIS. There's AIS that transmits, there's AIS that receives, so passive and active. I don't know what type of AIS this is that you're proposing, because it doesn't signify what, it just says AIS. I have a real issue with things that rules and regulations and expense in my business that doesn't create safety. And I honestly believe that putting AIS on my vessels would not increase the safety at all. I would even put it to you that it would decrease the safety, particularly in the Tasman National Park area. We've got a lot of pressure over there in the summer, lots of small boats. The biggest danger over there is boats that are underway hitting small kayaks and swimmers and people near the shore. Putting AIS on big boats is not going to mitigate or nullify that instance. AIS is the large vessels in the open water, seeing instances happening before they happen, like, before while boats are over the horizon, so the staff can alter the boats. What we need in the Tasman is we need skippers sitting at their helm station, looking out the window, not looking at a screen. We don't put screens in cars because we need people to look out the window and see the things that are out there to hit. That's what we need in the Tasman. The only reason for this AIS could be for monitoring operations. Okay, that's not a safety. And if somebody else wants to monitor me, then let them pay for that information that they want to. Don't expect me to pay for their information. That's not fair. Okay, number 3, the commercial levy. Sort of agree with Chris that it's not fair for the commercial operators to be funding all of those buoys and markers. at the moment, it's really interesting that every off-season, they take the marks away. I wonder why that is. Because the commercial operators don't stop operating. We seem to operate all year, and we still manage to operate without the markers. Yet come Labour weekend, you'll put them all back in. I put it to you, they're being put in for the general public's use. Don't charge me for the general public's use. Once again, it's like road signs. We don't charge airplanes. You know, everybody pays for the road signs. If those things are required for the public in the Tasman District Council, they should be funded, like all the other road signs and markers that are not lumped on one small group. Okay, I've got a couple. It's just about there. Very quickly, communication with 2 independent forms. It is not practical in a small dinghy in the Able Tasman if I'm going from boat to shore to carry 2 means of communication. Okay, I've got a mother boat sitting offshore that has the communication. I've got no phone reception, so that wipes out the phone as a means of communication. And the dinghy's too small to carry a VHF. It's another one of those silly little rules that isn't actually going to help. Lastly, guys, what I would like to do is 43.2 moorings. It's really great. I've been operating out of Kayak for 20 years. I don't know how many harbour masters that is, but probably about 5, I'd say. At least every year, we've had a meeting over there to try and sort out the mooring situation in Kayak. We've never managed to get anywhere with it. I'm probably one of the unlucky ones there because we do not have a mooring there. So we have persisted for the last 20 years on anchoring our vessels over the summer there. We've had 1 vessel lost at sea for 7 days, ended up on Farewell Spit. We've had 1 on the rocks on the island there. We've had another one in a collision with one of the other vessels. And even at the end of last summer, we had our new large cat drag at the end of the season. It would be really great if we can get that sorted. And in this proposal, there is a proposal to sort it. So thank you.
All right, thanks, Martin. I've got Rod King next. He's got a presentation. We'll bring the presentation up, Rod. Okay, thank you. Some of the thank you for having the opportunity to speak to everybody. I'm from the Nelson Stand-Up Paddleboarding Club, or SUP Club, and we're probably one of the largest clubs in New Zealand as far as stand-up paddleboarding goes. A bit hard to say how many members we've got, but probably around the Nelson Tasman region, there are literally hundreds of stand-up paddleboards out there. A lot of them are hardboards, which you have to put on the roof of your car, but the thing that's coming along now, there's substantial numbers of inflatable boards that anybody can stick in the boot of their car, carry on their back, take anywhere. And one of the things that's happening is that those sorts of things are now spreading into some of these other watercraft. A lot of these types of things that up there on the screen at the moment are basically ones that are powered by the wind, waves, and paddling, which are all fairly innocent, although now that the foiling board's there, quite a few of those can go substantial speeds on the water. But basically, it's a passive sport, and we're at the whim of the waves, wind, and other vessels on the water. One of the things that's coming along now, we're seeing these already in Nelson. People bring them into the country, are foiling boards. There's some of these battery powered. There's also ones that are a towed foil board where they have a powered like boogie board in front and they follow along on a rope
which is that a powered craft, and is it acting like it's a towed craft? So you've got a towed vessel, so does the same rules apply to that as would apply to somebody that's water skiing, for instance? One of the issues with some of these is that people that are using them don't realise that they are a powered craft, and they tend to go in areas that are reserved for swimmers, places like that. They're also, unlike a personal watercraft or jet ski, these you can put on the back of your car and virtually take anywhere. So more and more of them are going to be cropping up on beaches, bays, places like that. People can just bring them down to the beach, hop on them, and with long as it's charged up with the power, go off around the water, doing way more than 5 knots because they're foiling. So it's just another thing that they're a powered craft, or are they a powered craft, and what rules cover those. And it's one of the things that as paddleboarders, we notice a lot. A lot of people don't realise wake can affect paddleboards. People that are, say, new to the sport, and there are a lot of those out there, tend not to notice what's happening when there's a boat coming past, and wake can easily knock them off. And some of these foiling boards, things like that, are tending to do the same thing. They can go really close to people on paddleboards. They don't recognise 50-metre rules or anything like that. They seem to just take off on their own. But, you know, that's only probably a percentage of them. But the whole thing is that they're advancing, they're getting cheaper, and more of these are going to be on the water. You know, we think we've got issues with jet skis and other boats, but these are going to become the new I don't know, fashion, but anybody can go and buy one and get out there on it. And if they want, create mayhem. One of the main things about what's in the bylaw is there doesn't seem to be anything about leashes. One of the things about a paddleboard, we've got a thing called the New Zealand SUP Safe Code, which NZ SUP, which is the national body, put out. And in all of that, leashes or leg ropes are one of the vital things on a paddleboard. Whether you're surfing or just recreational cruising, if you come off, as long as you're attached to the paddleboard, you've got some chance of being able to get back on it. If it's windy and you fall off and you haven't got a leash, like the board will be gone. So having a leash is a vital part of what goes on. One of the things in Port Nelson is that anybody going out there, we make sure that they've got leashes on. All our people that go out paddleboarding usually use a leash. One of the issues we get is people that have gone and bought paddleboards on the internet. They come with no instructions, nothing. They buy a board. They don't realise they need a leash. They don't realise they need a PFD. And they bring it down to the beach, unpack it, hop on it, and off they go. So having leashes as a compulsory item on a paddleboard, to me, is a vital part of the safety. In some cases, in surfing, when people are surfing, they might not need a PFD or what have you, but it's a safety concern. If they're not attached to the paddleboard or the surfboard, they fall off it. The board can go anywhere, catch on a wave and disappear up into the sky and land on somebody. So having a leash in all those conditions, there's not really any exceptions. A lot of people now with surf skis and waka are using leashes attached to attached to your ankle, attached to your knee, attached to your waist. Some other boogie boards attached to your arm. But they're a vital piece of equipment to have. In some situations where there's strong currents on a river, especially like some of the rivers in Tasman district, you probably wouldn't want to wear one unless it's a quick release type. There's been instances overseas where the leash has got wrapped round, and in New Zealand, round a buoy, a mooring buoy, something like that, or an obstacle in the river or a tree. And once it gets wrapped round it, if there's a current there, you can't get free and you could be trapped in the water. So quick release ones in certain circumstances are the ideal thing. So if the wording or something similar was taken out of the code that we already have in New Zealand for SUP safety, in regards to leashes, that would be really good. Right, well, Rod, you're 5 minutes up, so you just need to come to a conclusion.
Okay, and the only other thing was with PFDs, that there are exceptions. Generally, everybody on a paddleboard is using a PFD, apart from in the surf. In the surf, usually people are using a wetsuit or otherwise a belt pack, and the belt packs inflate, pull the lead, and you've got like an aircraft type flotation device, usually at least 50 newtons, which is there to support you if you come off. So yeah, the main thing I think is just to make sure that leashes would be included. Got nothing against naming of things like paddle boards, but there are other boards like jet foils, surfboards that perhaps should have a name and address on it. How you do that isn't easy. A label or writing on it with a marking pen, which a lot of people aren't keen on writing on their board, but a label, unless it's a vinyl type that stays on there, isn't an easy solution either. So that's one of the issues, but it's a good idea. If people come off their boards and the board gets washed ashore and they go in another direction, somebody finds the board, they can immediately tell or get hold of the person and find out, are they safe or not? So I think that's it. So thanks very much for your time. Okay.
All right, thanks very much for that, Rod. Yeah. Okay, so there's nobody else here, but we've got some coming in at 2:15 as I see it. So what we might do is take a quick adjournment, have a quick cup of tea, and come back here for 2:15 for those people, because we've got to be here to give them time to turn up. Otherwise, we're in trouble. Okay, so that's what I think we'll do. Let's have a quick cup of tea because we've got 15 minutes and we'll come back because we've got a people on Zoom ready to go. And as I understand it, Stuart Whitehouse is first. Nelson Harbour Master. Stuart.
Good afternoon. Can you hear me?
We can hear you. I can't quite see you yet, but I can hear you. Hello, we can even see you now.
Great.
Right, so over to you. I think I might have met you. I certainly met one of your staff when it was very early in the morning leaving the boat harbour.
Good stuff. Hopefully they were nice to you.
Yeah, just told me to stay still till it was light.
Nav lights, eh? Good. Okay. So yep, I made submissions just around in general support of the direction of the bylaw, and there's some specific points around PFDs, life jackets, and that drive for compulsory wear below 6 for vessels 6 meters and less. And great to see some consistency coming along with that. Any questions there?
So we'll just see if anything. There's nothing from the panel that I see. We certainly had some comments about AIS from some of the other submitters. What are your views on AIS as a harbour master?
Yep, AIS is a fantastic tool. As I mentioned in my submission, it does have some limitations, but that's mainly down to the navigational level, and it shouldn't be relied on solely. But from a monitoring and a increasing levels of safety, I think it's especially Tasman's quite specific with your national park and the amount of traffic in that area and the amount of commercial operations. So I can definitely see its use would be invaluable there for monitoring, and from, I know there's known issues around speed close to headlands, for example. I think if people know that there'll be an element of they know they're going to be identified and hence hopefully act more responsibly.
All right. And I did note we had a submission from the board people. Are you seeing a proliferation of these different types of, I'll call them a wakeboard, or these motorized paddle boards type thing, or electric type paddle boards?
Is that a sort of from a foil board perspective?
Well, they look like a type of foil board, and also like a motorized paddle board, where somebody's got a little electric thing, or we saw a picture of one being towed behind like a drone.
Yep. So, and I've actually had a go myself. I helped a mate build one. I'm an avid foiler myself. So yeah, it's an evolving area, and it evolves a lot quicker than the rules do. That's for sure. So where we categorize these vessels, I mean, something that's been towed by a board that's got a motor and a battery, it's a power-driven vessel. That's the way that we view it, and all the same provisions as any other power-driven vessel should apply to that craft.
Thanks for that. I don't think those are my questions, and none of the other panel members have got any questions. And the other thing, I think consistency between the top of the south, is that what you see? Because I see boat owners across the top of the South Island. I use my boat in Marlborough, Nelson and Tasman. So I would think a lot of boat owners would do the same. Is that what you see?
Absolutely, and I think we're getting there, and certainly with the proposals in this bylaw review, it's going to make massive steps. We've had compulsory wear of life jackets since 2019, and it's confusing for people when it's not consistent. And there's been, like you're probably aware, there's been a big drive for national consistency, but that doesn't appear to be getting anywhere in a hurry. But you may hear from other harbour masters around that also.
Okay, well, thanks, Stuart. That's very good.
Pleasure.
And thanks for putting the time to come in and help.
Absolute pleasure.
Right. Okay, we've now got Jake Oliver, the Marlborough Harbour Master. So, Jake, can you hear us?
Yep, I can hear you. Hope you can hear me.
Yes, we can. Go ahead.
Cool. Thank you. Good afternoon, councillors. Thank you very much for hearing this one. In support of the Tasman bylaw, generally as it's been proposed, it's a good bylaw. It's got some really good structure to it. Picking up on the comments there with Stuart previously, consistency across the top of the South is key. Now, we acknowledge that the Marlborough bylaw was redone last year to tidy some things up. We are currently looking at our bylaw as well to redo that, and so what's being proposed, particularly around life jackets, around AIS, etc. This is what we're looking at doing in Marlborough as well, to make it easier for boaties travelling across the top of the South, or even coming over from Wellington, so it's one consistent picture. So absolutely in support of that. I picked up on your question to Stuart about AIS. It's not mandatory in Marlborough right now. We are looking at bringing it in. We need to go through obviously our consultation process, but what is key is from when we're looking out into the harbour, particularly in the Sounds, over vast areas, the visibility of where people are compared to commercial shipping, to other boats, is hugely advantageous. So it could only be in support of your council trying to bring that in. It's a safety tool. It's not perfect. There's always limitations with equipment, but it's a big step forward. And it's a very common thing in the marine industry now. This isn't new technology.
Okay, well, just see, I've probably got a couple of questions because I've been boating in your district for the last 20 odd years over the summer, and I've never had a run-in with you, so that's great. But I have certainly seen some bad behaviour, particularly with jet skis. But the question about IAS, what sort of passenger size are you looking at going down? Because you have those bigger water taxis, and then you have some smaller ones. So what sort of passenger size are you contemplating?
Yeah, so we're putting it through our team at the moment. It's discussion, but the thought process for us would be to look at being consistent with the Wellington bylaw. as basically trying to follow what has already been set as a standard. So we're not looking to do anything different. And I think Grant Nalder's the Wellington arm was best to speak to those limits. But we wouldn't be looking to do anything different to what someone else has already done.
Okay, and the one thing I've seen, and I stayed near Waikawa, and a bit out from that down the bays towards Port Underwood way, but seen a problem with jet skis, but I haven't seen a problem with foils. So are you seeing more foils in your area? And are you looking at identification of jet skis as well?
So yes, we are considering the identification of jet skis, registration. We haven't determined the mechanism for that yet. As for foiling, we don't see a whole heap of that in the Sounds. The wind seems to be fluky. It hasn't taken off yet where we are, but we do see jet skis, power boats, fizz boats. It's in pretty high numbers through the summer.
Well, you do get huge numbers of what I would call leisure craft, both sailing and boating. I've counted 50, 60 boats going out in the morning from Waikawa. That wouldn't be unusual, would it?
Yeah, we get we get a lot of sailing boats and these power boats, but yeah, so in the couple of years I've been harbourmaster in Marlborough, we haven't seen a proliferation of foil boards, and that there's one or two around, but it's not sort of big sport in Marlborough as far as we can see.
Okay, well look, thanks Jake. I'll just see if any of the other councillors have got a question for you. Councillor Butler has one.
Yeah, thank you. Look, just in relation to identification of jet skis, we're looking at the option of having identification of the trailer, using the trailer rego as well. And I just wondered if you had thought of that, or if you had a view on that. The registration of a trailer, vehicle trailer that would carry the jet ski.
I think that could be a good option to be looked at. There's either go trailer reg or go through the 6-digit unique identification number. Either or allows the a system behind it that it makes it easy for harbourmasters to be able to follow up and have a conversation. What we do more is we have a lot of conversations with people, and we try and encourage good behaviour. So whereas people think it's compliance with a big stick, it should be really looked at in the behaviour and get good compliance. Voluntary compliance is what we want.
Yeah, Jake, I hope you can hear us better because you're cutting in and out a bit, but we've certainly got the gist of what you've said. So thank you very much.
Thank you.
That's useful. We'll now go to Grant, who's the Wellington Harbour Master. I think it is. Grant Nalder. Grant?
Yeah, kia ora, good afternoon. Thank you for having me here. You've got a good lineup of us today.
Yeah, 3 of you. So yep, that's good.
That's good. Echoing my colleagues, consistency, and I'd go further from top of the south to actual national consistency, and that's what all the regions are working towards. I suspect you're more of a destination than Wellington is. For some reason, people don't come to Wellington to do their summer boating. But
well, that's because I was there recently and your climate's not too flash.
No. Well, I grew up in Nelson. I know what your climate's like, and it's much nicer. So, yeah, I support the changes they're making. The life jackets are good, the communications. Now, the AIS, we do have that. We introduced that in our bylaws here. You're asking about the criteria. We've set it at passenger boats carrying more than 12 passengers or any charter boats operating at night is the criteria there. We've also had a slightly broader one if the harbour master feels it's necessary. That's been in relation to work boats and the like that are working around the commercial part of the port. It gives everyone better visibility, both as regulator, you can see what's happening, you can see where the boats are. It gives the operators better visibility of where they are. You get a rain squall, if it's evening, anything like that. You're not actually guessing what boat it is or where they're going. It gives you a positive identification. If you want to talk to them on the radio, you know who it is. It does change behaviour. I heard mention of speed, and It was voluntarily fitted to the harbour ferries here a number of years ago, and it has changed how they operate for the better. So it is the fact that you're being watched, it is a tool for behavioural change. If you get the argument of, well, why pick on the commercial ones? When the public are paying to go on a boat, there's a higher level of safety and a higher expectation of how they operate. They are surveyed craft, they are qualified operators. There's a there's an expectation when you pay money to go on a boat that you come back safely, and AIS is definitely a good tool around that. What else did I just made a couple of notes? Yes, we also have jet ski registration, and we have gone with two options, either the trailer registration, because that's already a nationally managed database and saves having to recreate anything, or we have provided the option of working with Auckland Transport, who are very generally accommodating other regions. They've got the biggest database by far, and it gives the operators two options. But I think trailer registration is a really nice. It makes compliance simple, and when compliance is simple, more people will comply with it. The other thing I was going to comment on, I believe there's been some interest in swimmers around jetties and jumping off there. Our bylaw is slightly different. We have prohibited area around wharves if there is a boat manoeuvring. So essentially, where you've got a wharf that most of the time isn't in use, it becomes a recreational facility, but it is much easier for someone standing on a wharf to see a boat approaching than a boat to see the swimmer. So it becomes an education point that if there's a boat coming in, they need to have right of way to get in and off that jetty. And I think that was the points I'd made. So yes, are there any questions?
Just say, well, I've got one, and Councillor Dakey, let him go first. So Councillor Dakey's got a question.
Hi, Grant. Yeah, thanks for your comments there. You've got a comment here about Part 91 and getting together with the Transport Minister. Do you want to give some comments around it? Is around the PFD changes, or have you got some more to add to that?
It is broader than that. It's unfortunately Part 91 has been overdue a review for a very long time. It has stalled at the Minister of Transport. We wrote to a previous minister. They weren't, unfortunately, in the office particularly long. And by we, I convened the Harbour Masters group nationally. So all the Harbour Masters are writing to the new minister, backing Maritime New Zealand's push to actually get Part 91 reviewed. That would set national standards for things like life jackets, communication, all the like. There is no time frame on that. It's down to the will of the minister. And so that's why we're working to try and get bylaws consistent as they come up for renewal. What I would envisage when Part 91 gets reviewed, I'll say optimistically, is that it will be very similar to the majority of what we're doing now for life jackets.
Thank you, Rod. Appreciate the work. It'd be great if the government led for change, but thank you.
It would be very good, yes.
With government, always be careful what you wish for. Okay. We're getting some changes in other areas that maybe we don't wish for. Grant, I just you did touch on safety with AIS. So we've had some submissions where they say it won't make it safer. You've had that in place for a number of years. Has it made your harbour safer? That's the question from that.
Yes, I believe it does. We have a slight difference in that we have a mix of commercial and recreational vessels, but among the recreational vessels, as I said, there is a behaviour change. They will tell you that they comply with the rules all day long. If you actually if you put AIS on them and follow them, initially they might not be quite as good as they thought they were, and you will see that change happen. And I heard a comment passed about water taxis going around headlands. I've spent a bit of time in Marlborough Sounds, and on a quiet Tuesday afternoon, that 200 metres around a headland gets very, very short. I suspect AIS would see a difference with that. in your area, you're looking at a very mixed use between your kayakers, your small craft, and your powered boats. And actually that 200-metre buffer offshore is a very important safety zone. And yeah, I believe you would see a change in operator behaviour.
Yeah, I do note that the Marlborough Harbour Master over the years has put out a lot more buoys 200 metres off headlands. So as a boatie, you can certainly, you know how far you're off. I know that we don't have them on all our headlands in our bays. So certainly in Marlborough, they're pretty well marked, certainly where people swim.
Yeah, there are, but there are a lot more headlands than we can litter the place with buoys. So, and again, we're talking about commercial operators. They're running to a professional standard. We should see compliant or you should see compliant operation. And like I say, we have seen behaviour change here with the introduction.
Okay, well, I think that's all our questions, and I'd just like to thank the three of you. It's great to have three harbour masters that are near us, and your combined experience is very useful for us.
Cool.
And we've got an expert harbour as well, who's not giving evidence because he's going to answer some questions from us from Canterbury as well. So
He will be very good and knowledgeable on that too.
Yeah, so it's been very useful for us. And the consistency, I think, is a really important thing for around the top of the South Island, and certainly people nip across to Wellington, but not in the size boat I run. That's for sure.
Good to hear. Okay, thank you very much.
Okay, so I think that is the end of our submissions, and we now turn to reports. And it'd be good for Peter and Amy and the team to come up rather than sitting way back there, so that you can go through your report, and then I'm sure there will be a number of questions, certainly some things that have arisen, and I gave you a bit of a hint, well, we had a couple of tea breaks about some extra things that have come up. So we've read your report, Amy, but I'm sure you'll probably want to enlarge on it. And there may be some questions, I'm sure.
Tēnā koutou I tēnei ahi ahi. Good afternoon. This bylaw will provide the Council with the regulatory authority to exercise control over specified maritime safety matters. It allows for either prosecution or infringements in the forms of fines for specified non-compliance offences. Consultation on the draft bylaw ran from 1st of August to 1st of September, and we received 256 submissions, including 21 late submissions. There were over 160 submissions strongly opposing clause 12.1 that unintentionally banned swimming or diving around landing places, and staff have recommended this clause is corrected. The main theme of the rest of the public feedback was general support for the bylaw, particularly the requirements regarding personal flotation devices, vessel identification, and communication equipment. Other key themes included support for AIS tracking, although some commercial operators raised concerns, strong support for the river speed uplifting provisions, although JBNZ requested the QMEC ratings and an advisory clause be removed, and mixed views on the proposed navigation aid levy. The role of the panel today is to consider the views of submitters from this hearing and from the written submissions, deliberate and decide on any changes to be made to the bylaw, and decide whether to recommend to Council that the bylaw is adopted. Peter, Paul and I are here to answer any questions you have as you deliberate. We also have Ian Fox on Zoom. He's currently the Canterbury Regional Harbour Master. He's a qualified Master Mariner and a member of the National Navigation Safety Group's Bylaw and Rules Working Group. He's very much a technical specialist on navigation safety and has been assisting with us with submission analysis and forming recommendation, and he is also available to answer your questions today. Section 6 of our report summarises the submissions by theme and recommended changes with staff advice. Attachment 2 to the agenda report is an overview of submissions to assist with your deliberations, and attachment 3 sets out the proposed changes to the bylaw with rationale. These changes are also tracked into the consultation copy of the bylaw, which you have as attachment 4. A navigation safety bylaw must be made in consultation with the Director of Maritime New Zealand. Staff have worked closely with MNZ throughout this process and received further feedback on whether matters they raised had been addressed by the changes made for consultation. Staff have proposed some further changes to the bylaw in response, as set out in attachment 3, and the outstanding matters are covered in paragraph 4.13 of the report. The LGA requires the Council to determine whether a bylaw made under the Maritime Transport Act is the most appropriate way of addressing a perceived problem, whether the proposed bylaw is the most appropriate form of bylaw, and if there are any Bill of Rights implications. Staff have considered the proposed changes and remain confident that the bylaw is in the most appropriate form. Staff advise that the bylaw does not give rise to any implications or inconsistencies under the Bill of Rights Act, and are reasonable and justifiable means to address the identified problems related to navigation safety in Tasman District. Finally, the Maritime Transport Act enables the Governor-General to make regulations by order in council prescribing a fine for offences under the bylaw. The associated 2016 regulations are administered by the Ministry of Transport, and once the bylaw is made, we will work with them to have them updated with infringement fines for offences under the bylaw, and this process will likely run into 2025. Thank you.
So I think easiest thing is to go through these subject by subject, if the other panel members are keen on doing it that way. And I was just trying to bring something up on the screen, and I was struggling with my computer. It's damn. Who loves technology? Not me. And I thought we'd do subject by subject, and the ones that are contentious. So the first one, I think the most contentious one was the amendment to section 12.1, right? So that's the jumping off the thing. And there was one submitted today who didn't like the exemption. I could ask Peter, what's the speed that tide runs out at? Is it about 5 knots at Marpur? Or is it 7? Somewhere between 5 and 7.
Yeah, it depends on the spring or neap tide. But we've certainly clocked it at over 5 before. I've not measured it at 7, but certainly 7's bandied around a lot as being a speed that it can reach.
So if you've got valve to steer your boat, you've got to be. That's why you've put that exemption in, as I saw it. And I've voted that area.
It's also in Maritime Rule Part 91. So although it's not in 2022, it's in Part 91, the exemptions, or it's sort of not inconsistent with the national rule.
Yeah, and we've amended this to allow, and I saw a lot of submissions from Lake Rotowedi as well, and the school that obviously came in late, so it obviously became a classroom project, which is a good thing because it means that's great civics. It means they're interested in what's going on in their district. So that your amendments allow them to continue on with their activities. Certainly in Lake Rotowedi, they'll be competing with the eels because where they jump there are very large eels, and that's where people feed them. So you're happy that the amendment will allow people to continue jumping and swimming. All right, Sia, you've got a question. So that's the first one.
Yeah. I just
do them subject by subject.
A little bit more detail or refinement about, it does say that the boat takes precedence, and so if people are in a high recreation area, so is there any situation where a boat would need to wait if children were about to jump off, or is the expectation that children, say, like 10, 11, 12 young teenagers or whatever, would have to wait, or would the boat be required to wait? I'm just thinking about those more, slightly different situations where they would expect to be able to jump and not expect to see a boat.
So I think the start with that one is that, once the bylaws gone through, there's a lot of education to be done around that, around signage and increasing awareness. The biggest thing there is it's not going to be one shoe fits all, particularly Mapua, if you have got 7 knots of tide running, and if there is maybe someone who's flustered or inexperienced at the helm, that could cause a problem. So I would always err on the side of caution on saying one rule fits all for that scenario. In an ideal world, I think the boat does need to have right of way in that situation. Having said that, if you've got a group of people that are consistently swimming off the wharf, certainly at nights of Nelson Lakes, then it is appropriate the boat wait for 5 minutes to bring it back a trailer down. But you can't say that would fit every scenario, because if there was a reason not to, then
So it's a matter of judgment.
An experienced boatie will be going against the tide if they're coming into the wharf rather than with the tide. So he won't be going that fast, will he? But someone who's not experienced might be going with the tide. So, but everywhere else they're going to be within that 200 metres, so they should be down to 5 knots. And I've certainly known in Nelson Harbour they have a 3 knot limit in certain places as well. All right. So Glenn, in relation to that.
Yeah, so 12.1, we've got a 50 metre, so no person shall jump, dive, or undertake activities within 50 metres. The old bylaw was 30, I believe. Does the 50 relate to a national standard or a uniform number? Where does the 50 come from? Especially when you think about Mapua, does that seem relevant?
So the 50 metres is consistency with Part 91 and the safe speed. So when you're within that area, you should be doing 5 knots anyway. So it just seemed smart to align it with a national framework.
Makes sense.
Just another question. So the explanatory note down the bottom, this is really just a reflection question. Does the Mapua and Lake Rotowedi situation, is it clearly laid out there for people, that understanding? Do you feel this, if you were reading this as a layperson, that you would understand that you could still partake in those activities given the distances and the way you might read it? And that's just really a question to reflect on, because you could possibly, and it was some of the submitters mentioned that today, perhaps you could read this that it is partially still prohibiting you from doing it. So it's just a thought there around that note and just some clarification if it actually achieves what you wanted people to know. It's just a comment, wasn't a question, but yeah.
Yeah, fair point. I think we can easily, or it's a lot easier to change explanatory notes if they don't become clear. However, I think a lot of that will be around what signage and what education we can put around that. And I think it's more important we get the signs right at the locations than necessarily the explanatory note in the bylaw, because the kids that are going up to school aren't going to have read this document.
Sorry, can I just add to that, just to be clear that explanatory notes within the bylaw don't form part of the rules. They're just advisory clauses. So yes, good question. The alternative would be to include it as a rule to make it clearer. But it's just some extra information for consistency and to help interpretation.
So we should go from the start. The first one was person in charge of a vessel. Ian's got his hand up. Ian, there you go, because I wasn't looking.
That's all right. No, good afternoon. Thanks for having me along. Just some context for the information Peter's already given you is the clause there is based on a template that was written by the Harbour Master SIG that Grant shared some years ago. I'm guilty of having been the person who drafted most of it. The rule as written, 12.1, is very similar to what we have here in Canterbury. In fact, it's almost identical. And we have several years now, since 2016, of testing that in the real world, including how the explanatory note has been interpreted. It was a deliberate decision to have that as a note, not part of the rule too, by the way. Thus far, with a little bit of education, it's worked out quite well. And in the small number of places in Canterbury, because our weather is much more dire, of course, than you experience in lovely Tasman, it hasn't really been an issue for people once they've understood it. And there have been a small number of occasions when we've had to use this in a more pointy way down here. Our experience thus far is that the rule actually works, and we think it would. I reckon it would probably work for Tasman quite well once people get used to it.
Thanks for that, Ian. I wanted to, so that's 12.1. I wanted to go back to 8. So you've changed the wording slightly about the person in charge to operate a vessel. Person shall operate a vessel. No person shall operate a vessel while impaired. That makes sense to me. I was quite happy with that change. I just want to make sure that everyone else is. I'd ban alcohol on small boats. I've seen too many accidents over the years. You just shouldn't do it. One law. Yeah, different law, but you know, you're on the water. You got to be safe. So nobody makes good decisions when they've done partaken of drugs or alcohol, and boats are dangerous. Nobody's disagreeing with me, so that's all right. So that's 8 and 12. And 12.2, that was covered. So the next one where the changes are is the identification 30 vessels to be identified, right? Amy, am I going I'm doing this in the right place? I think I am. So questions in relation to this, and there was some comments in relation to what's a vessel and how do you go down to, you know, we've got boards and everything else on there. But our particular problem, as I see it, has been jet skis in particular. And I've seen it in Marlborough as well. And I remember some problems in Wellington at the Porirua Basin in relation to that. So anyone got any questions or concerns? To me, using the database that's available with registration numbers of trailers makes sense to me, because you're going to have, it's got to be a certain size, this sort of thing. Then you've already got an existing database and it doesn't cost anything. What do the rest of the panel think about that? Glenn, you've got a comment?
Just some clarification around there. We had support for, you know, from the paddleboard group for, say, labelling paddleboards. Where do you see the practical endpoint size-wise for a vessel being for this sort of rule? Have you given?
So I think there's a clause in there exempting paddlecraft, so a paddleboard wouldn't require identification anyway. It was never the intent to require that. We do ask for dinghies and things to be named somewhere on the vessel. So in terms of we can find the contact details, but the thing about that would be somewhere in the boat. So if it washes up on a beach somewhere, we can track down who the owner is, and it'll be really good to see that on stand-up paddleboards and things as well. But we have provided an exemption for paddlecraft from that clause.
Celia?
So for kayaks, sit on top kayaks, they would have to be identified. It's not
yeah. So they're paddlecraft. So
yeah, they're paddlecraft, right? But so the other thing is that the identification is seen to be solving a problem, which is the behaviour of jet skis, and so with the trailer registration, are we saying that there's two alternative options about whether the jet ski needs to be labelled as well, or are we saying that jet skis need to be labelled full stop, regardless, you know, that the trailer registration is another means of identification, but not the complete?
So in the rule and the clause, we talk about trailer registration or VHF call sign being the preferred two methods. So that there is a choice, and both have a fairly comprehensive database we can access. For larger vessels, non-trailable vessels, then we can look at other options, you know, unique names and things like that, other than the make and model. But I see no reason why jet ski wouldn't have a trailer registration. So no, they're required to have the trailer registration.
Right, because there is, we've had jet skis riders actually saying that they can't be identified and so they can therefore do what they like. And that's just the worry that they may be able to get around that trailer rule. Yeah.
No. So if the jet ski has a trailer, then that should be displaying the trailer registration on the jet ski so the vessel can be identified.
Councillor Dowler.
Yeah, just an operational question, really. I know people that loan their jet skis out to others. So if an infringement notice is going to be given, you stop. You say, I've got the registration number. Do you then, this is operational, ask for the person's name, because the person who owns the thing is going to get something arrive in the mail probably. And you say, I'm not paying that. I wasn't riding it. Just to cover off what would be the technical requirement in that situation.
So in the bylaw, we've got provision to infringe upon the owner of a vessel. So if they don't tell us who was driving, so if we didn't catch them and we saw footage or had substantial proof, we could still look at enforcement regardless. However, that will be quite a way down the line. It'll all be education to start with, and making sure they are identifiable and things to start with. So, I can see sending out warnings to start with, rather than enforcement straight away. But there is provision to change, and just like with your car, if you get a speeding ticket from a camera and it wasn't you driving, you can say it was so and so. Same sort of story. Yeah.
So while we're talking about vessel identification, one of the concerns that I've seen raised today is the proliferation of motorised boards. And so these are motorised foils or whatever. I think it's going to be hard. I'd be interested to see if Ian has had any comments on that, but certainly I do see them around here. And I'll be interested in your comments. How many are we getting and how do we accommodate this going forward? Because we don't want to amend the bylaw it's so difficult. So Ian, are you seeing motorised foils in your harbours in
Yes.
Canterbury?
Yeah, definitely. Not as many as in some places, but we're certainly seeing them. Our attitude is very much in line with the other harbour masters you've heard from today, that if it is powered in any way, it's a power-driven vessel and we treat it as such. If it's unpowered, it's a non-powered vessel and we treat it as such. We see no reason at all to separately define them or rewrite rules that are getting down into the nitty-gritty of being vessel-specific, like a foiling board. It doesn't make a lot of sense to us. It could be unduly confusing. So those ones that, like the e-foilers, we just treat them the same as we do a powerboat. No difference at all.
Okay, so Peter, what's your view too? So
Yeah, exactly the same. It's come up at several harbour masters meetings about this issue, and everybody's on the same thought that until such time as a sort of government want to step in with some sort of oversight of a specific type, we treat it as a vessel and power-driven vessel.
Because my understanding is they can go at a reasonable speed. Would that be correct? They're doing what, 30 knots? Or maybe 20?
Yeah, I don't know what the top speed is, but I don't think they do 30 knots. I've certainly seen them do that at sort of 18 to 20 knots, yeah.
Does that answer any queries in relation to that? So you just treat them so to be the same as any other vessel if it's powered? Powered?
Yeah, just because it's a foil, where would the ID be put on that?
Good question as to where the ID would go. Most of the power-driven vessels that we're seeing, of powered foil vessels that we're seeing in and around Nelson, I've not seen too many in Tasman yet, are actually powered by a towed craft. So the paddle board that's in front would be the thing that needs the ID on it. And that's something that they're going to have to figure out where to put it. That is an issue they're going to have to come across, and it will very much depend on the brand and the type as to where that can go.
Yeah, because it could be tricky because, like your requirement for a powerboat is 100 mil visible from so many meters. So we'd have to get that right, I think. Yeah.
Okay.
So I just wanted to query that as we go. The next one I see we've got to change is the obstruction of vessels moving in a prohibited zone, where you're making a slight change. That's number 33, isn't it? So it's in 3 nautical miles of the coast of Port Cherukuri and Motueka.
So the logic behind having a moving prohibited zone is around these large vessel management. So we're seeing increased large ships coming to anchor in the region, super yachts and cruise ships. It's going to be hard to expect them to apply the giveaway rules if they're going into an anchorage that's particularly confined for them. So this moving prohibited zone is an easy way of giving them the right of way in an enclosed space, but it's not much good having, they don't really need that along the west coast, for example. So but by narrowing it down to the coastline where it's needed, it's a lot more effective.
What I've seen is those what I call petite cruise ships that are carrying about 200, 300 passengers. I certainly saw them last season on more than one occasion, moving from Kaiteri towards Nelson, and obviously they probably go around the edge of the Abel Tasman. Would that be correct?
Some of them even anchor in Anchorage Bay itself. Yeah.
Any questions on that? No. The next one with significant changes where we've modified it is in the fuel changeover. So you might just need to explain that to us. So that's section 36 where you're making changes.
So quite a lot of harbour masters have rules around fuel changeovers in their harbour masters directions, sort of standing direction. And he can speak probably more on that if he wants to. I don't have any standing directions, and I don't necessarily see the need to without a major port. However, it is a significant risk around fuel changeovers where there has been incidences in the past of vessels getting in trouble during a changeover. So just limiting what state they enter our district in is a smart way of doing it. The way we had the rule originally written, we were basically mimicking what a lot of other harbour masters do in terms of requiring it 4 miles out, but you can't really affect what state the ship will be in 4 miles out. We only can deal with what's in our region. So it was seen as an overstep. So by putting it back in with a change, it makes it more in line.
All right, Ian, will you want to just comment on that? Because we don't see those great big vessels, but I do recall a vessel that left Wellington and then got into trouble and got towed back to Wellington, but it was going to be in I think it was in our waters when it was disabled. And our concern is, of course, is our Abel Tasman and the Farewell Spit, and vessels coming into our water and they become disabled. So, Ian, any comments?
Yeah, so you have vessels heading towards Nelson that go through that northeastern corner of your region, so it is applicable. The risk with fuel changeover is sometimes what happens is when a vessel changes from heavy fuel to usually to a diesel for manoeuvring, they sometimes black out, and that is, you've got a ship drifting around with no power, and the rule here is aiming to mitigate against that by having them change over a reasonable distance off. The wording that Peter has drafted for you now very much mimics several harbour masters directions that are around the country. The reason they're in as directions is it's quick to do. We spent quite a bit of time consulting with various industry players on this when it started, and it was in relation to New Zealand signing up to what's known as MARPOL 6, which is an annex to the International Marine Pollution Regulations around the use of fuels compliant with those regulations regarding sulfur and various other things like that. So what's happening now is there are more ships that run on these heavy fuels, but when they approach land, they are no longer permitted, and it's similar here. And so that's why there is no national rule around this. We desperately want one, but there at the moment there isn't a mechanism for the government to put one in. So that's something that's being worked on now. In the meantime, this is being done on a region by region basis, and the strong feeling amongst harbour masters is that as long as we're consistent as possible in the wording around the regions, it doesn't really matter whether it's in a direction or a bylaw as long as it's there.
So this is consistent with what's happening in the rest of the country then?
Yeah, very much so.
Progressively.
And it is a real issue. It hasn't happened often in New Zealand. When it has happened, it's caused a significant amount of consternation. It has resulted in some significant incidents overseas, though, and we'd rather avoid it happening here, of course.
I wholeheartedly agree with that. Any questions in relation to this from the rest of the panel? No? Okay. The next one we come to is the thorny one, the carriage of, well, it certainly caused some angst among some of our commercial operators. So this is the AIS, and I think you've changed the wording slightly. That's correct, Amy? To transmitting of automatic identification system signal.
Correct. So we've amended it so the requirement is to transmit a signal, and that amendment aligns with Wellington's AIS clause, rather than a requirement to carry, which is Maritime New Zealand's concern around requiring extra equipment to be carried.
So I'm sure there'll be some questions on this, and you saw that we've had some pretty vigorous submissions, and that's why I particularly questioned the other harbour masters in the area, and I want to ask Ian the same sort of question. So Ian, do you have this in your bylaw in Canterbury?
No, we don't have it in the bylaw, nor do we have it in a harbour master's direction. The number of vessels that this would be applied to in Canterbury is very low. Like I could just about name them, and it would be a short list. We have thought about it, but what we've done instead down here is speak with the local operators, and we've had fairly good buy-in so far. It's been quite slow, but we're certainly at the point where there are enough people lagging behind that we're thinking about it, but not quite there yet. What Wellington has done and what your proposal is, we would be following in this case if we were to go down that path. It does make a lot of sense, and there's an increasing acceptance around the country from having spoken to my peers around New Zealand for this kind of thing amongst operators as well. A lot of people get grumpy about it when something like this first comes in, and I can understand that. I'm no more of a fan of being regulated than anybody else is. It's part of my job. But being able to be seen, once people realise the benefits of that, it makes a real difference. The biggest change in behaviour that I've seen in Canterbury has been entirely voluntary, and it's come from the fishing sector. Small inshore fishing vessels started to voluntarily fit AIS to their boats, even though they didn't need to. There was no legal requirement for them at all to do it. And they did it because some of the areas they were fishing in had a significant amount of commercial shipping, and they simply wanted to be more visible to commercial boats. So there's one benefit of something like this. Reading some of the submissions that have come in, I noted a lot of the commercial pushback was about if you're transmitting an AIS signal, then not everybody can necessarily see it. Well, that's correct in some ways, but it's not impossible. There are many free AIS viewers available that you can view from a website or from an app on your phone. So as a small boat user, even if you aren't transmitting a signal yourself, you can still pick up the signals from around you. And there's some advantage in knowing that from a recreational boating perspective, that if you've got regular transiting ferries or water taxis that are have a commercial reason to fit to a schedule, for example, then knowing where these things are before you duck out, simply so that you don't interfere with them, is of great benefit. And certainly for the number of boats that we have in Canterbury that do that, mostly the cross harbour ferry, or ferries, there's two of them now, and some of the commercial boats in Akaroa, we've had some feedback from the public that they appreciate being able to know when things are coming more in advance. And this is people who are actually looking at the likes of marine traffic too. So overall, I'd certainly see it as a benefit. And I think it's almost inevitable that everywhere else will follow what you're proposing here at some point.
Kim, I think you've got a comment, and then I've got a couple of questions, but I'm sure my fellow councillors have too.
Yes, thank you, Chair, and kia ora to you, Ian. How are you?
Very good, thank you, Kim.
Good. Just picking up on your point about the behaviour of the commercial fishing industry being influenced, one of the reasons that sits in behind that is every single commercial vessel in the entire country is obliged to comply with the vessel monitoring system requirements. So they've been conditioned to that. It's means that the authority to manage the regulator knows at every point in time where every single vessel fishing in accordance to its quota entitlements is. And so from that level of responsibility, I think you've probably seen the behaviour that Ian's talked to in Canterbury about saying, well, actually there's a benefit to this. Let's spread that to the AIS systems that they've obviously adopted. So that we're not alone in the need to improve our knowledge of where vessels are at any point in time, and we're in a sort of a shared regulatory space in this regard.
So I'm sure others have got questions, but the first question I was going to ask, and then I'll go to my panel, is how many commercial vessels do we have operating in our district? So I'm thinking of water taxis, Wilsons, everyone else. Do you know what the rough total is?
We're talking just that this rule would apply to, so commercial passenger vessels, or
what this rule would apply to. How many vessels have we got?
Between 20 and 30. So around the 25, 26 mark.
Yeah. So a reasonable number. All right. So
what we heard from submitters was the cost. And I'm just wondering if there could be a time, some kind of delay whereby they have to be fitted within a certain time, but not necessarily straight away. That's my first question.
So it's in the rule that this rule doesn't come into force until 1 September 25. So we're already allowing a year. Almost.
Yeah, I was sort of thinking whether it could be more than that, because that's actually not very far away for, business planning ahead, and whether or not it'd be possible to actually, I don't know what the rest of the panel think, but actually stretch that out for 2 years, seeing it's quite a new thing. But the other thing is what actually is the benefit of it if we're thinking of Able Tasman and, the unique nature of the setup at Able Tasman, where you've got, relatively sheltered waters and where these water taxis don't go beyond the sheltered waters. And do you think that, what benefit of it is to you as the harbour master? Is it so that you can know where they are? Is it so that other vessels can know where the water taxis are? Is it is it for safety? I just remember, one of the submitters said, don't make a rule just for the sake of it. So I'd just like to feel, to hear it justified for the park.
So I think it's multiple reasons for the park. We know how many vessels there are. We don't know how many trips they do. We don't know how frequently they are done. Obviously, they've got a schedule, but their schedule doesn't tell us how many boats are going up and down. For me, it's going to be around traffic management. So if we know that we actually have 24 boats going into Anchorage at 3:45 every day, then we've probably got quite a big problem that we need to address some other way. But we don't have any data on that, and there's no way of tracking the vessels without a system like this. Knowing where there are is one key thing for that. Having the data to track over time is another key factor. Also, just that behavioural change that Grant talked about as well, to me is huge. It's been incredibly difficult to prove beyond a doubt which boats are speeding when and where. Case in point is one company that has a lot of the same colour boat, and they basically go, we don't know which boat you're on about. So I can show them a picture and they go, oh, don't know. And we've got thousands of pictures like that, and we get sent them, I think, I think I got 27 phone calls on my day off in summer, from people complaining about operators. So it's, being able to know definitively whether it was or wasn't them. Because a lot of the time I generally believe the operators are really good. We don't have such a big issue, but being able to prove to anybody for or against, to me, is going to be a really key thing moving forward.
So it's a management tool.
Could I add a couple of comments to that as well? So coming back to what we were looking at as the initial problem that we were trying to address, with this being the solution that we're proposing, the issue being all the commercial pressure and the high speed traffic density along those areas in the coastline, particularly over summer. So when we were looking at the issues, we could either do nothing, so don't regulate the issue at all. We could regulate the number of vessels, so limit how many vessels were allowed up and down the coastline at any time. We could look to introduce small scale traffic separation, so lanes, backwards and forwards. And then the other option was the vessel tracking to monitor the risks and provide data. So a key reason for that is to better understand the pressures, as Pete's talked to, and provide data to inform future reviews and future options if we need to do something more in the future. And the benefits for us is that it is a increasingly key advice to ensure safety and compliance. If you've got a fleet that all look the same, it helps us identify which vessel is where. It links closely to clause 53.3, which provides that ability to issue an infringement to not just the person in charge of the vessel, but the owner or the operator. And there's also some benefits to the operator that have been touched on earlier in terms of them tracking their own vessels over time, being able to protect themselves, I guess, from any complaints, being able to provide the data to show that they were on track and within speed in the search and rescue.
All right, Barry, you got a question? Councillor Dow.
Actually, so are we going to have someone monitoring this 24/7 or what?
No. So I'm not planning on monitoring it at all, really. It'll just be on a case-by-case basis. If we get a complaint, we can look up and go, were they, weren't they? I don't see that we'd be needing to monitor it. I think just having it on board will see a change in behaviour anyway.
Yeah. I just heard a comment from both, actually, that if you saw 24 movements in and out of a bay during the day and or there's too much traffic going up and down, you'd look at limiting it. Now, that's actually council controlling the operations of a business, which I don't think we can do. So I would be very disappointed if that was going to become part of the track. I can understand being able to identify where boats are and if someone gets into trouble or whatever, but
I've got no plan to limit the number of vessels. It's more about whether there needs to be more measures of control around where they land on beaches and whether they're all congregating in the same place, not the number of trips. Yeah.
And just to clarify, I was talking about having it in place provides the data for future review. So if the data tells us there is an issue, next review of the bylaw could look at options to address an issue that we have data to support. So the first approach is not to start putting in speed lanes. We can't do that outside of the bylaw.
Ian's got a comment, but I just wanted to me, what I got from the other harbour masters was about modifying behaviour and it had improved safety. Having been out with your predecessor on a number of occasions, jet skis was the worst thing that I saw, but I also saw boaties that didn't like following the rules. But my understanding is not everybody follows rules, and it can be a recreational boatie or a driver of a particular boat who might be a commercial boat because they employ staff. I didn't see the business owner here. I saw the operations manager. That was correct? Right. Ian, you've got a comment to add on this?
Yes, as far as monitoring 24/7, so we have an AIS system that's our own terrestrial stations that monitor our entire coast. We can play it back up to 6 months at any time, and beyond 6 months by asking the service provider for it. So if we hear about anything, it allows us to wind the clock back and see a replay of what happened. We pay for that service. any service that provides that you're going to have to pay for, whether it's one provided by an international company or a local New Zealand company like ours. You can see what's happened in the past, even if you weren't watching it at the time. It makes it quite handy, actually.
Right, Ian, what's the cost of that? Because we're a very poor council, not like
Yeah,
the Canterbury region.
Yeah, well, we're not exactly flush either, to be honest. I can't tell you what the cost is because it's commercially sensitive. Unfortunately, we get a bit of a special deal from our provider, and they don't want us to tell anybody else what that is.
Because you're bigger, that's why. Councillor Dakey.
So I've heard some concerns around the cost of implementing it on a larger fleet. Councillor Butler is talking about possibly considering, if we are to go with approving it, a longer time frame. The initial cost would be somewhere in the realms perhaps of 2,500 for a commercial vessel. Is there an ongoing service cost to use the service for them? And then my other question is, there was mention of them being a short-lasting device or becoming obsolete. Can you comment on that? So really, what's the cost, the ongoing cost, and how long is it going to last if they put them in? Thanks.
So yeah, you're dead right with the cost. Around about the 2,200 mark is what I've had a local quote for an item. I would assume if you're going to order 14 of these things, you might get a decent discount as well. And then obviously the installation cost depends whether they can do it themselves or not. And then most of the operators would probably do it themselves. The maintenance of the units, we've had it on Sentinel for 8 years, never had a maintenance issue with it. Previous jobs I've worked in with it, I've had them on a 6.5 metre open boat. As far as I'm aware, it's still on that vessel 17 years later with no maintenance issues. Can't guarantee that one, but yeah, from what I'm aware, talking to the skipper the other week, it's still there, and that vessel lives outside with no roof. It is an open boat. It lives on the back of the Spirit of New Zealand. Has AIS, has done for many years, like I said. It's not my experience that these units fail. That's certainly, they normally just you plug it in and it goes. There's no subscription fees, there's no annual costs. Just sort of goes like that. In terms of being obsolete, I don't know what is around the corner, but AIS is widely used in all maritime functions all around the world. And I can't see that changing anytime soon.
How many complaints can you recall last summer about speed that caused you concern? Between the two. So that's the sort of question I didn't give Amy before, but I think it's relevant because this is about safety. So how many complaints about speed did you get roughly?
It's hard to tell you any sort of precise figure because we've actually given up logging the complaints we get around speed. I've certainly over this last summer would be receiving between 5 and 20 complaints a day around speed related incidences. A lot of them I do take with a grain of salt because a lot of them aren't follow upable. Like there's literally nothing I could do even if it was true. Paul, any comment on that one?
Yeah, I agree with what Pete said, and take into account it was a quiet summer. A couple of years ago was a really busy summer, and we would have got a dozen calls a day in the peak period.
So in terms of complaints about speed, are you able to separate them out with how many were about jet ski behaviour, how many were about boats? Because I think that's important because I've seen behaviour problems with jet skis, and we've had people killed in parts of this in New Zealand with jet skis on harbours. And I'm thinking particularly of Pororua many years ago. Well, it's not that many years ago. But so what are your complaints generally?
So most of the time it's been vessels in and out of the likes of Kaiteria anchorage and going through anchorage areas. And then Mapua would be another area. The jet skis generally maybe 1 or 2 a day out of the dozen. Mainly Golden Bay and Mapua and estuaries for jet ski complaints. I still do believe that the IDing is the first step for that, being accountable. Where the registration follows. But that's a much harder thing to implement than an ID.
You know, I know of 2 countries where all vessels are registered, you know, both in Canada and in Australia. If you've got a small boat, you're registered. Makes sense to me, but that's a national government thing to do, not us. But I think this makes sense. Any other questions about AIS? So Councillor Butler suggests we take an extra year. I don't think I could be convinced that it should be an extra year, but I could be convinced that it could be 6 months, maybe. So what are your comments on that? Because if you want to spread, because it's a commercial cost of doing business. These operators in Golden Bay are licensed also through dock, aren't they, to land?
So they have concession through dock as well. Yeah.
So they pay dock a certain amount of money? Because I understand, like with fishing guides, you paid $1,000 for each concession, roughly. They pay 50%. We actually get some money sometimes.
Yeah.
Right. So.
Yeah. So we do get some money from those concession fees, and I'm meeting with Doc pretty much quarterly. And then there's the meetings that Kim goes to as well for the foreshore reserve, which is where the concession money goes to. In terms of the timeframes, I would say that the sooner the better is obviously what my opinion is. However, I can understand it's a big cost. Whether there's a reason to say a percentage of your fleet could be done by a certain date and the remainder of your fleet done by a certain date rather than it being one lump sum. I think there might be some benefit to that. So say by 1 September, 50% of the fleet must be, and then give them another year for the next 50% or 6 months, however you decide. I think that could be looked at, for sure.
Barry, you've got a comment?
Yeah, well, just two comments here. I'd like to see 2 commercial seasons involved. So that would be the 18-month period, which would give them hopefully enough income to do for the bigger operators to do it. Having run a business myself, the government changed the rules, it can smack you around fairly quickly if you're not established and going properly or whatever, or even if you are. I reckon this is great. Don't get me wrong, I think this AIS is going to be a good thing, but I just look at my involvement with Motueka Airport. We went to that AIMS system to record the number of flights in and out at the Motueka Airport. And all of a sudden, the government or CAF said, no, we're going to put it in Taka as well. And it's costing an absolute fortune. I'm just wary that if all the areas do it, someone's going to pop up one day and say, you'll use the system and that's how much it's going to cost you, just like it is with the AIMS. And it could get quite expensive quite quickly. That's a fear in 5 years' time or something. You know, I know how the system works.
So what's the best way of doing it if we want to give them a little bit more time, saying that's what I'd like to.
Can I just add in, so when we're talking about costs for operators, there's the one particularly large operator with 14 boats in his fleet.
Yeah.
So looking at a quote of 2,200 per unit for installation, that's going to cost him 30 grand to put that on all 14 boats. So I guess you're deliberating whether that cost is acceptable over to 1 September or 50% of his fleet, or if we give him a 2-year period as the biggest cost to one particular operator.
Well, which I'm looking for a steer from Peter. Which is better, 50% for this first summer? Because if the drivers don't know which one's got it on it or whatever, so half of it.
Yes, so the 50% would have to apply to all operators, not just to the one company.
Yeah.
And yet the other operators, the other 2 big operators in the park are actually.
They've got bigger boats and they're less of them.
They've got less of them and bigger boats, and they can see the benefit for this. And one of them submitted in support of it. The other one hasn't submitted at all. I think it depends if we're trying to split the costs so that they don't have to pay the one bill, because if we give them 2 years, they will wait 2 years to pay anything. Yeah, so I think the 50%, if you're going to go down that road, then that's useful. If it's about giving them 2 seasons, then 18 months and do it that way.
So your preference is 50% by that first date and complete by the next. What do the panel members think about that?
Most, well, a firm with a big number of boats, he'll have his primary boats, maybe 5, 10 or whatever, and then 4 in reserve if he gets too busy. I don't know how it works. I'm not a boatie. I don't go up and down that often, but would he have 14 boats on the water every day, or just 10 primary ones that go out every day, and if he gets overloaded, he brings the others on board?
Pretty much, yeah.
Yeah, so, 50-50 or whatever you've, I need a guide, but that's me.
Well, my preference would be 50% for this first date you've got, and then complete by the next one. Because then that means we should see some behavioural change, and it will improve safety. But it's behavioural change that we want, as I understand it. So we're spreading the cost, so we're giving them a clear signal. What do you think? That's my preference.
Yeah, would it? I know it's picking on people, but a minimum of 7 boats in the first 12 months or something, and then so the bigger operators with a less number of boats, it makes them do it in the first 12 months. If you understand what I'm saying.
I think it's probably better to keep it fair for all operators, so they all get the same rule. So if you're saying, so that will only apply to one operator that has more than 7 boats. So I think that would be seen as an unfair advantage.
Yeah, I agree. I think 50% that first date. So we have to modify that in here. So somebody's got to record that. Yep. But
can we just clarify about the commercial sailing company and how many boats they've got, because that is where we heard this too. So if we said 50%, then we would say that we're giving them a break. Yeah, thank you. And as that, because there were 2 commercial sailing companies, but one of them operates mostly out of Nelson.
Yeah, so there's one sailing school which is out of Nelson, so he's got 2 boats, and then the other one is Martin Holmes, who's a concession holder, whose boats would come under the 12 passenger rule anyway. So whereas Sail Nelson doesn't carry 12 passengers, I think he's limited at 5. So he only gets caught by the nighttime one. So Martin Holmes would, Able Tasman Sailing would be covered by the 12 passengers. There is also, we've not really mentioned it here, but there is room for exemption clauses on this one. So the likes of Mapua Ferry, there's no benefit to him having AIS. So he could apply for an exemption. And the same thing could follow suit if we feel that Martin Holmes' Sailing Adventures smaller vessels may not require it, but that would be up to, we'd have to come up with that, and it needs to be, the exemption needs to be approved.
The exemption, that makes things a bit easier. Yeah.
So to me, the best is 50% of your boats by the date you have, and 50% the next season. So
the amendment is 50% of the fleet to be transmitting an accurate AIS signal by 1 September 2025.
Yep. With
the full fleet transmitting by 1 September 2026.
Yep. So that gives them 2 seasons to, and I think we've been quite generous. But it should start to modify behaviour. So it'll be interesting. You'll know at the end of the first season whether it's modifying it or not, which will be interesting. And then we're consistent with the other harbours in our district, so or in the top of the south. So that makes sense. Right, so that's that one, and that covers 38. Then you've changed the wording in criteria just about the maps, isn't it? But you've just deleted some stuff.
Yes, correct. So those were carried forward from the last bylaw, and we're not clear why. We can't see any good reason for them to be included. Right. The criteria one in particular was requested to be deleted by the criteria rec reserve.
And the other one is Rabbit Island.
Rabbit Island clause is the same, so that was carried forward. It's the same ban that we're now deleting. That deletion is supported by 3 submitters who want to be able to kite board in that area at Rabbit Island.
Yep, we've got 9 kilometres of beach, so there's plenty of room for everybody out there, really.
I think one of the big things for that is for the bylaw, we can only take into account the navigation safety clauses, and we can't see a reason why that area is unsafe for those craft.
Agree. And then again, you've done inland waters. So you've deleted an area on some maps.
Correct. So we've deleted the advisory clause that Jet Boat New Zealand viewed as unclear and unworkable. We agree the existing maritime rules are clear enough in covering safe passage on rivers. We don't want to add any confusion to that. So that advisory clause has been deleted from those river maps.
So we certainly had some submissions from Jet Boat New Zealand, which basically want to be able to drive as fast as they like at any time. That's what I saw. And we're not proposing to change that. And the other thing is the QMIC thing. If we change that, we would have heard from Fish and Game, I'm sure, because I'm thinking of the Motueka River, fishermen's, and jet boats and jet skis that I see actually on the Motueka River. And once it gets too low, it will just cause problems. Oh, Ian, you've got your hand up too. So Ian, you've got a comment?
Yes, with what you just said clearly in mind, Katie's assertion that there are no other similar things anywhere else in the country is incorrect. Canterbury has one of those. It was originally brought in by way of a temporary measure on the Tekapo River. Jet Boating New Zealand asked to be able to boat up that river because it's one of the home rivers of jet boating, the Tekapo and the Pukaki. Of course, that's where Bill Hamilton lived. And with we facilitated discussion sessions between the other users of those rivers, Fish and Game, the whitewater kayakers and rafters, and with Forest and Bird as well. And there was an agreement that it was most appropriate on that river to set a flow limit for exactly the reasons you suggested. Below 20 cumecs, it's quite widely fished and a very popular place for backcountry picnicking and camping. But above 20 cumecs, most of those uses are absent because the river's too high. It floods into some of the popular picnicking areas, and it's the flow is unsafe for people to stand in the water to fish. So that's why we have a cumec limit, and I expect exactly the same would apply to the Motueka and other rivers as well.
Yeah, from my experience, you'll just end up with disputes on the river, and I have seen fishermen throw fairly large rocks at boats. Wasn't me, it was my father, but I have seen it done. And I mean, that's what will happen. And you get literally hundreds of people on our Motueka River. You don't get as many on the Buller, but to me, that cumec thing, and I know that I think you're going to monitor it for a while, but we would have a lot of submissions if we were changing that. Celia.
Yeah, if it's for the rivers in Golden Bay, the cumecs is really important because they're recreation rivers with swimming and all sorts. So the cumecs is the one thing that actually keeps down the traffic of speedboats on the Taka River in the Aorere. So I totally support keeping it.
And you would have had problems at your river mouths in the past, but you haven't got any salmon there now, so there's not as many people. You used to see 200 people. You used to see 200 people at the mouth of the Rangitata 20 odd years ago. You don't now.
Yeah, and the Rakaia as well. It's been pretty dire actually. All my friends who fish, they're suffering. They've been having real issues with it.
So we need to keep going. So the next one is the commencement date. So you've added that in, okay. I'm just going through all these things. Unseaworthy as well, you've amended that slightly. Anybody got any questions about that? That's for you guys. To me, it made sense. And reserved areas, and so you've changed that. We did get submissions about the estuary and jet skis, and we're complimented that we're now going to be able to have identification, so they'll be able to identify people, I would think, if they've got decent binoculars. But have you got any comment on that? Because it's certainly not a great place to ride a jet ski where we've got native birds nesting.
So I think the first thing to remember is that we've got to only take into account the navigation safety risks for this bylaw, and we need to look to other measures for environmental impacts and environmental concerns. That being said, with this bylaw, I've tried to address the major issues to the national sort of thing, which is the life jackets and speeding and those sort of identification. I haven't looked at each different reserve area. That's something I would like to address through a risk assessment before we do the next review, so that we can go, hey, maybe the ski lane needs to be moved over here, or maybe that. But we just haven't had the data to support any of that, whereas we know what was there was sort of safe. We didn't have many accidents where people were injured. So we're keeping the status quo. Seems the safest route until I can risk assess on the new data.
The estuaries are so shallow that it doesn't suit, because I've certainly seen boats run aground in the back of Rabbit Island trying to get to where the salmon are, where the snapper are, and they're only in 10 foot of water, but it runs out really quick. So it is an issue, but it's an issue that you could maybe work with the estuary group over the next 5 years, because it has to be done again in 5 years, if I understand it. Glenn?
Yeah, thank you. So we were at Grosley Point yesterday, and the Mayor made a comment particularly about the signage. And I understand there's some work underway to clarify. And I guess part of that is, do you think that the people on the jet skis we see, in the wrong place, do you think it's an education issue, or do you think it's deliberate action? Do you think they're aware that they're not even supposed to be doing it? Do you think there's an improvement in signage and education would be a method, or do you think it's going to more enforcement may be needed? Which way do you think it would be? Do you think they're aware?
I think it's both. I think it's already been mentioned today that there is a certain amount of people that go, I can't be identified, so I can get away with it. So the ID sort of hopefully solves that or helps combat that. And then if we're rolling out the education and the signage at the same time, I think we're coming at it from both methods. The signage has, will be a bit slower to roll out than we wanted. We didn't get a grant that we were hoping to get for that. So that's going to be a multi-year project rather than a rolling out this year. So that might take a bit longer than we wanted.
Thank you.
Celia, you have a question about that?
Yeah, so in some of the estuary areas, we've got a lot of them. So the 500
200 metres.
200 metre rule applies, doesn't it? And so there will be people that will be breaking the rules just from that point of view.
Yeah, so I don't know if I can't remember what submissions we got from Aotearoa, but I know there's been a lot of people in Aotearoa complaining about some signage that I had put up last summer around skiing in the estuary, something that they've been doing for years. And how did we make a rule banning it? And I said, I didn't make a rule. It's a 200 metre rule. It's a national rule. All I'm doing is saying that there is nowhere in that estuary that meets those requirements. It's always been banned. It's not a new thing. I'm not changing the rules. All I did was let DOC put the sign up. Yeah.
So from west of Abel Tasman, including Aotearoa, it is the 200 metre rule, isn't it? That is the thing that is, people don't understand about it, but it is the most effective, the only effective thing that we've got really to try and slow down.
Yeah, and this is a national
vessels.
rule. So this is a Part 91. So even though we don't currently have a bylaw, we can still enforce that 200 metre rule. Yeah.
It's just from the photos we saw, people obviously ignore it, and I've certainly seen it. So that's 200 metre, right? So the next one was vessels maintained, and so that we've made some changes, Amy. Anybody got any questions about this? I know you have problems with unseaworthy vessels and vessels abandoned at times, and it costs us a bit of money to get rid of them because they become a hazard. And identification of the owner actually becomes a problem because the person could be deceased if it's been there for 5 or 10 years. That's what I understand. Would that be fair? That they just get abandoned if somebody gets too old to look after them
Yeah, so there's several ways we can deal with this. One is obviously with what we're proposing in the bylaw, and there is a national rule I can declare as a REC and clear it up with national rules. It is quite a lengthy process. The change here is purely to line it up with other councils and the national sort of draft that Ian had a party to, and it's worded in a way that will reduce potential risk to council.
And we didn't get anybody opposing this, as I understand it, so it makes sense to me. Everyone else is happy with that. That's number 9. And then the other is 23 access lanes. You've just made a minor change there. I think it's just a numbering change. And you've changed the one in relation to flags, because that didn't necessarily work, so I see it.
Yeah, so you know, the whole idea of this one is that we want vessels to be clearly visible. Is that for flags? Yeah.
Yeah.
Sorry, I've just got identified on my list, but it's fairly visible. The use of a flag for certain vessels can be more dangerous. Especially if the vessel rolls over, you won't get it right up right again. And we didn't have it in the clause; we had it in the explanatory note anyway. So just basically removing that so that we're just saying they need to be highly visible. My preferred option, and it's a thing I'll talk to the kayak companies individually, so that, you know, as they replace their life jackets, they can put high vis on the life jackets. You know, that's an easy thing to do over the time.
Very hard to see when it's a short chop, basically. You've been out there, and I certainly have. It's hard to see them in a short chop, so that helps. And then you've got vessels accurately secured.
So we've changed the word abandon to the word leave. The word abandon has a specific meaning under the legislation in relation to removing abandoned ships, and that's not the intent here.
Yeah. So
the intent here is if you just leave it somewhere where it may refloat and cause a hazard.
So it needs to be secured if they're leaving it there without it refloating and disappearing. That's common sense to me. If you're a boatie, you've got $20,000 or $100,000 worth of boat, you want to secure it. Your insurance company won't be very happy if you don't. No, and then now anchoring, which is designated anchorage, pretty sensible there. And you've changed number 40. So that's just about if you're concerned about safety by the looks of that.
Yeah, so this was a sort of controversial one with Maritime New Zealand as well. Possibly Ian might be the best person to comment on this one, as soon as though he put it in first, I think, in Canterbury. And it was mainly to deal with people operating sort of hire businesses out of, you know, back of their car, really, without any knowledge.
Well, there are people certainly hiring boats in our district. Ian, any comments on this number 40?
Yes, Kim might remember the Aquanauts case in Lake Tekapo several years ago. It was a freedom hire operation, what's known as that. So they don't fall under the normal MNZ oversight. They're not commercially operating boats, and because they're not guided, they don't fall under the adventurous activity regulations. So essentially, they're unregulated. We saw there was a real need there to provide some sort of supervision. So that clause was drafted aimed at that type of operator specifically. That it could be applied somewhere else, but there was no real other way of writing it than we did, and we only applied it to those operators. And it's so that we've had several since we brought it in where there's somebody doing freedom hire. We pop along, have a chat, say, you know, ask them for their standard operating procedures and, you know, what the limits are for operation and how far away they allow their clients to go from base. And the initial response is usually blank stares. And we then institute an education process. We give them some examples of commercial operators and guiding operations and what they sort of have to use as a template. We've been very successful so far with getting the standard of operation up to the point where universally everybody we've engaged on this basis has actually thanked us, because they've ended up feeling much more comfortable about their own operation, and it gives them something that they can say to their clients, where they can say, we have a process for looking after you. It's been worthwhile, and other regions around the country have since done similar things as well. We were just the first on this, and several others have copied it, and it works.
Yeah, Ian, I know some operators in Marlborough that hire smaller boats and up to 10, 15 metre vessels. They have a process you have to go through if you want to be a skipper of one of those boats. And then they give you some training before you go out if you haven't got a ticket. So that's certainly it's something similar happening in Marlborough with these vessels. And some of them are worth, you're hiring something that's worth $300,000.
Yeah, that's really good that they do that. And for those kind of boats, that's been fairly common practice for a long time. The ones we've had issues with are a bunch of kayaks off the beach. That's that sort of thing. And particularly somewhere like Lake Tekapo, where in that case there were 2 fatalities, simply because the boats weren't properly equipped and they had no safety procedures, no requirements for comms or anything. Those are the ones that we were particularly interested in. And no doubt you'll have the same kind of thing too.
Yeah, so we had a similar thing in Maraho a few years back, and I think council ended up doing enforcement of their RMA for trading off the beach without any consent or permissions. But the issue, the biggest safety issue, was that he had no plan for operating the kayak rental. You could even take this further and use it to provide some guidelines and things for the likes of Airbnbs that are having kayaks on, and for use for everyone, so that there is some sort of thing looking after them. Because they won't be voluntarily doing a lot of this stuff or applying for any permissions from anyone else. Whereas if we can say, hey, here's some advice on this. This is the clause that it relates to. Yeah, we're supporting them rather than just leaving them out to dry if something went wrong.
Everybody's happy with that, so we'll just go. Allocation of mooring licenses, there's just small changes there.
Yeah, they came from the TRMP team, just requesting those changes because the mooring area bylaw didn't come into effect last year. So it's just a correction to make sure it's still accurate.
And the other one that we had a submission on was fees and charges. Okay, so is that relating to the fees for commercial operators pay a small fee for buoys, I suppose is what they're talking about, wasn't it?
Yes, we've got a couple of fees and charges in there. The one that was commented on today was the navigation aid levy, and that's to replace a commercial vessel license fee that was in our old bylaw, which is no longer allowed to be there, basically because of the change in the Maritime Transport Act. We always use the funds from that to pay for the voyage. I completely see his point around the seasonal voyage, and it's something I would love to change over time, is that those markers will be permanent. That's the way I would like to see it go. Not necessarily all of them, but a majority of them, because the rock doesn't change. The rock's there all year. It's not just there in summer. So those sort of things I think do need to be looked at. However, it is rate funded 50-50. So the actual cost of doing this isn't coming completely from the commercial operators. It's a 50-50 split, and I can track that data quite easily.
So ratepayers that don't have a boat are subsidising those that do, and the commercial operators who operate in our area pay part of it as well. I don't think that's unreasonable, but I'll defer to the others. So Glenn, you've got a comment?
There was a comment in there that perhaps some of the navigational aids weren't up to a particular standard. Would you like to give a comment on that? So it's an area I've changed our levels of service through the long-term plan proceedings, and one of the things I put on, or one of the levels of service that we're changing to from a licensing that was in there, is to navigation aids. It's an area I really wanted to draw attention to. It's an area where I applied for funding and didn't get as well, so it's going to take a bit longer, but it is something that I am really keen to address. I recently received a delegation from the Director of Maritime New Zealand for placement and changing of navigation aids, which is something the Tasman District Council have never had in the past. So we're
we're starting that process of upgrading and doing things as correctly as they can be done. Cost will be the prohibiting factor on that one.
Barry, Sheila, any question about that? Okay.
Yeah, we'll have to go away and redraft that clause so that it's accurate, so we can circulate that to you before we include it. Yeah, absolutely. So basically, we're saying commercial operators to ensure 50% of their fleet comply by 1 September 2025 and the entire fleet by 1 September 2026. Thanks. We'll get advice on how best to word it. Cool. Yeah, we will. So the referral report will go to the 24th of October full council meeting. So there's plenty of time before that to agree to changes with the CEO.
Sorry. We've heard from the late submitters. I'm sorry, Ian, I had my thing off. We're just looking at the motions now that we have to move. So, in fact, Ian, does anyone have any more questions of Ian if you've got other work that you want to do? But I'm sure Canterbury's not charging us by the hour anyway.
Canterbury isn't charging you at all. I'm not here as an employee.
That's
of
really
ETN.
nice. Seeing
I'm
as
here as an
Canterbury
individual.
opted out of local government in New Zealand after making a whole lot of money. So
No, I'm here on my own bat, just from my own experience.
Well, that's great.
It's partly because Pete's come in new. He's doing an excellent job, but I thought it might be nice to give him a hand, and also partly as a thanks to Kim, because I have my job because of Kim Drummond.
We won't hold that against you.
Yeah, that's all right.
I've worked with Kim over the last couple of years. But at least his brother supports the Highlanders, which is very important. Yeah, because he's a part owner of the Highlanders. Right, so let's just so is everybody happy with these so far we've gone through? Right, we'll scroll down if you are. Right, there we go. It's the most appropriate way. Notes proposed does not give rise to any implications under the Bill of Rights. Sets out the reasons. Right, and we've gone through each of these changes and discussed them, and we've only made one change to the proposed. All right, so that's in relation to the AIS. And from my perception, it was really good to have those other harbour masters on board to see what effect it's had for them. That was really useful for us, because Ian, you've got a slightly different situation in Canterbury because you don't have as many of these chartered operators. It would have been interesting to see what they have in Queenstown and land in there, because they get lots of people on their lakes. So, anchoring.
they're watching our bylaw closely because they don't currently have it and they'd like to know what to do next.
Yeah.
There's that for a review next year.
They have a lot of charter operators on the lakes, that's for sure.
Can I just interrupt before you jump down further? I think you may need to make a resolution to amend clause 38.
All right.
That would be covered under the minor amendment.
Okay.
You sure? Because it's only it's saying 50%. It might be more than mine.
Not entirely changing content completely. Only a minor implementation.
I guess it's a matter of interpretation. It's certainly
careful that would be just say amend section 38 in that as discussed.
and recorded the minutes or something like that around delaying the dates. And then we've got a record of it, a resolution linked to the minutes and gives a clear instructions to the staff.
Further up, sorry, Evan.
AIS there.
So 5.8.
Yeah, 5.8. Why don't we just put in and amend as discussed to 50% the first year and 100% for the second year. And we'll do that. And that means that we've got that recorded.
Through the chair, what we could do, just so you guys, it's
I'd like to thank Amy and Pete and Paul for everything. Dwayne, you probably had to check it before it came in. And Amy gave extra time on Monday. Ian, thank you in particular. Yeah, Kim owes you a drink next time he's down there. You might let him into your new stadium when it's finally finished.
Yeah, I think we will.
Sorry about your rugby team. We did beat you this year, and we've got the shield, which makes everybody happy. I'm going to come to Councillor Butler to do the closing karakia, if you would, thanks.
Kia hiki te korero, kia watia, kia mama, te manawa o te tangata, kia uki te ara mō tatou e ora nei, ko rongo ki runga, kia tine, huye tai kie.
Thanks, everyone. And